I'm Carla Peterman, and I'm chair of the California Commission on Catastrophic Wildfire Cost and Recovery. We are here for our second meeting of the commission on March 13th in Redding, California. This meeting is being webcast, and we thank all of you who are here for your participation in person, and greetings to everyone who's on the phone lines. I'll call this meeting to order. We'll start with a roll call of commissioners. Commissioner Michael Kahn. Here. Commissioner Pedro Nava. Here. Commissioner Michael Wara. Commissioner Dave Jones is not present today. First, let me begin with one agenda change, and let me take a moment to introduce our executive officer, Evan Johnson. He is sitting to my left. And for those of you who are in the room and will be providing public comment, there are cards for you to fill out on the back table. And you can hand those to Edith, who's sitting over here to my far right, or anyone that you see as a part of the staff. We'll get into why we're here in a minute, but just a few ministerial administrative changes. For agenda changes, we have one additional panelist on our third panel. For the community needs around wildfire damages panel, we'll be joined by Director Patrick Minturn with the Shasta County Department of Public Works. So we look forward to his participation. Executive Officer, any other agenda changes?
Not on my end, thank you.
Great. Before we turn to some initial public comment, let me just take a moment outside of my chair's report to say hello, good afternoon. Thank you to everyone in the Redding community for welcoming us to have this important meeting here today. Your community and your neighbors have been affected by the catastrophic and devastating wildfires we've seen in the state over the last several years. And we're very much looking forward to your input regarding the costs and liabilities that you've seen and any recommendations you have for the state as we move forward to deal with this crisis. We have an opportunity for public comment at the end of our agenda, but we appreciate that not everyone can stay until the end. And so if there is anyone who would like to make public comment now, you're welcome to do so. If you are able to stay, we would ask you to reserve your comments until after each panel, and then at the end for general comment. With that though, please come forward to where, I'm not sure yet, if you'd like to make public comment now. But why don't you, if anyone would like to make public comment, if so, come into the aisles. There's a microphone here. Sir, do you have a card?
I gave it to Edith. Yeah. I have another card on there.
Okay. Great. Well, I'll just ask that you introduce yourself for our record.
Certainly.
And please.
Certainly. And good afternoon, Commission.
I think your microphone's not on.
Do I?
And we're not putting time limits on public comments, although in the interest of time, I ask that you keep it under 3 minutes.
Good afternoon, Commission. My name is Cedric Twite. I work for Sierra Pacific Industries. And just to cut to the finish line, I've got a suggestion for the Commission, a recommendation you all might entertain making, and that is to support the Board of Forestry in emergency rulemaking, the California Board of Forestry to undertake emergency rulemaking procedures to revise the emergency notice for fuel hazard reduction. Currently, that process is underway at the board, but they're taking the regular rulemaking path, which means that tool, after it's revised, will be very effective for private landowners to implement strategic fuel hazard projects, but it won't roll out until January 2019. And as a large landowner in California, we have actually a strategic plan where we're going to implement a lot of different strategic fuel breaks throughout the Sierras where we own property. Well, actually throughout all of our ownership to protect watershed resources, our timber assets, and also important wildlife elements. And it would be really helpful to be able to utilize the emergency notice for fuel hazard exemption, emergency notice for fuel hazard reduction sooner rather than later, especially if it gets revised by the board. Thank you.
Thank you. Next, we'll hear from Baron Browning. Is that you, sir? All right, I think you are next. The screen is telling me something different, but you are here in front of me, so please introduce yourself and welcome your comment.
I'm John Schaefer. I'm here on behalf of our grandchildren's future. My concern is that there's not enough money from traditional sources, PG&E, insurance, and governments, to pay for victims' losses in 2017 and 2018, more so into the future. Society shouldn't abandon those climate victims damaged by fire, floods, and landslides. We had fires, of course, in California long before it was California. Firefighters tell us now they're much worse. That's climate change. So who's to blame for climate change? I am. And so is everyone who's burning fossil fuel. So in fairness, we fossil fuel burners should pay for some of those damages that we cause. California can arrange this, thereby covering climate victims and encouraging all of us to use less fossil fuel. That's the only way we can restrain climate change. The devil is in the details. We need to change SB 901, which authorized paying off PG&E's probable liabilities with what they call non-bypassable fixed recovery charges on every electric customer. Not the right way to do it. And then we need to enhance cap and trade fees at the California Air Resources Board. Instead of non-bypassable fixed recovery charges, I propose victims' climate losses be covered, at least partly, by additional CARB fees on fossil fuel users. This is sound economics, Pigovian fees to internalize external costs, and it's sound legal logic, charging tort damages to those of us who are responsible. Both are bedrock principles for a society that takes care of itself. Most affected by these decisions will be young persons. Let me quote one. "I want you to panic," she said. "I want you to feel the fear that I feel every day. I want you to act as if the world is in a crisis. I want you to act as if the house is on fire, because it is." This was Greta Thunberg. Thank you.
Thank you. Would anyone else like to bring us public comment now? There will be an opportunity after each panel to provide specific comment on those panels, as well as general public comment at the end. Next, we're going to turn to approval of our consent calendar, which includes the minutes from our February 25th meeting, as well as our scope of work, which had some minor modifications coming out of our last meeting. Executive Officer Johnson, do you want to speak to the changes in the minutes or the nature of them?
Sure, thank you very much. The minutes were posted earlier this week, and we have a few minor revisions to them to accurately reflect the testimony that was received at the last meeting. We did make a few minor changes. Those will be posted after this meeting, and they're in the commissioner's materials as well. Those are minor and largely not substantive changes.
Commissioner Nava, did you have a comment or suggestion?
Yeah,
And
oh, there. Thank you. So on page 15 of the minutes, the paragraph where I'm making some remarks as it relates to the requirement of insurance, the next to the last sentence, it says, which then results potentially in a for sale or foreclosure of that property. What I said was an enforced sale, but I can understand why you would have heard enforced sale. Other than that, I'm fine with the minutes.
Thank you for that clarification.
You're welcome.
Thank you, and I'll remind everyone that the minutes provided represent the notes taken by staff. For a full accounting of the meeting and transcript, please refer to the webcast video, but thank you to staff for putting together such a nice summary of the discussion. Any other proposed changes, commissioners? Yes,
Are you doing the scope of work at the same time? Because I have a comment on the scope of work.
we are.
Okay, great. Just for a moment, I did want to highlight the two changes that were going to be made to the scope of work pursuant to the comments that we received at the last meeting. It should be up on the screen here. I believe the commissioners all have it in their hands. There's two minor changes. One was to get rid of the word current in bullet number 1 there in the scope of work. And that was much discussed at the last meeting, so hopefully that reflects the requested change. And the second was sort of a grammatical error, was said number 3 said recommendations on a fund, a mechanism, and we took a mechanism out and just left it as a fund to accurately reflect the statute in 901, statutory language under 901.
Thank you. Can I get a motion for the consent calendar?
So moved.
Second?
Second.
All those in favor say aye.
Aye.
Aye. Do we need a roll call? Okay. We're gonna do a roll call. Commissioner Hahn?
Aye.
Commissioner Nava?
Aye.
Commissioner Ward?
Aye.
Commissioner Peterman? Aye. So approved. Now, the time in our agenda for a chair's report. I'll keep this very brief. I just wanted to start by saying at our first meeting, we had comments brought to us by the Director of Office Planning and Research where the Wildfire Commission is housed. And Director Gordon pointed out that the Wildfire Commission, our commission, is one of the many state entities that's working on how do we address the wildfire risk and make sure that we have safe and healthy communities, as well as those communities have access to the vital services like electricity and water that we'll be discussing today. Her testimony outlined well the various initiatives happening at the state, so I'll refer you to that video. And we are here to do our part in the discussion. This commission was created by Senate Bill 901 and signed into law in 2018. And this commission is tasked with examining and addressing issues related to wildfires caused by utility infrastructure. In particular, we're directed by the legislature to provide recommendations by July 1st for how to equitably and fairly allocate costs related to wildfire liability. The 5 of us here were appointed by the governor and the legislature. We all bring different expertise to this role. We are all serving in this capacity on our voluntary time because we believe in the importance of the mission of this commission, as well as the need for the state to address this overall challenge. The legislation also requires us to have at least 4 meetings around the state. We had our first meeting in Sacramento a few weeks ago, and we have our meeting here in Reading today. You can follow the commission's website for details on future meetings, and we'll get those posted as soon as possible. As you can imagine, given the tight timeline we have and the quick turnaround we have to get recommendations to the legislature, and some of the logistical challenges with scheduling meetings, sometimes all commissioners will not be able to attend every meeting. However, those who cannot attend, for example, Commissioner Jones today, will have available to them the webcast as well as any formal or informal comments that you file. We appreciate Commissioner Jones' support for us continuing forward with this meeting, and we look forward to him joining us in the next one. With that, I have no more introductory comments. I'll turn to my fellow commissioners, though, to see if there's anything anyone wants to raise before we get into the agenda. Let me turn to Executive Officer Johnson for his report.
Thank you, Chair, and I similarly will keep this short since we have a lot of expert testimony lined up and a lot of public comments. And I think people would like to share their perspectives on this, so I want to reserve our time for that. I will use the Executive Officer's report simply to say that we have been receiving public comment, and that has been posted online in advance of this meeting and shared with the commissioners as well in your packets and in the binders in the back of the room. We will continue to collect public comments as they come in, so please do submit a comment either short, brief comments on perspectives or long, detailed comments with data and information for the commissioners. Everything is welcome. The work in front of this commission is significant, and we welcome all the expertise that can be brought to bear on that. So thank you, and I appreciate continued support. And I did want to take a moment to thank the commissioner, the chair of the commissioners, the City of Reading, and of course everyone in this room here for giving your time, and especially for those who travel a long distance. Really appreciate you doing so. Thank you.
Also mentioned that in our first meeting, we set the stage by having background presentations about the utility industry, the insurance industry, and wildfire risk. I commend those presentations to you. They're on the OPR website, opr.ca.gov/wildfire for further background. We also decided in that meeting that in each of our meetings around the state, we would hold a couple of panels where we take expert testimony on a couple of key issues. Our recommendations can and may expand beyond what we hear in these different meetings, and you're welcome to provide us written comment or testimony on a broad range of issues. But these are the issues that came up in our first discussion that we thought warranted a deeper dive. With that, without further ado, let me introduce our first panel. Our first panel is focused on existing wildfire liability and the legal regime. I'll ask the panelists to come up, and when you each speak, we'll have you introduce yourselves. Oh, pardon me, please. Don't listen to me. Scott, come on up. Let me welcome Scott Kavanaugh, Deputy Attorney General, Tort and Condemnation Section, Office of the Attorney General. He's going to be giving us just some background on the framework that exists for legal liability in our state. Welcome.
Good. Thank you, Commissioner Peterman. Rather.
Yes, and we need to get you a microphone, so
okay.
let's hold for a second. This room is new to all of us, and so appreciate everyone's patience.
Is the green light on?
You want me to come over there?
Why don't you come to the podium and we'll get the wireless cord.
Again, thank you, Commissioner Peterman. My name is Scott Kavanaugh, and I am a Deputy Attorney General in the Tort and Condemnation Section in Sacramento. And I have been invited here to talk to you about the law of inverse condemnation as that is applied to privately held utility companies. Now, before I get started, I want to offer a disclaimer. This is not legal advice or legal opinion. This is just a synopsis of how the law stands today. First question is, what is inverse condemnation? Inverse condemnation is the opposite or the inverse of eminent domain. As you may know, if the government seeks to take property from a private individual, it may do so, but it has to pay that individual the fair market value for the property. Now, in inverse condemnation, it occurs the other way. A property owner believes that the government has taken his or her property and must pay them for the property taken or damaged by the government project. And this is all guaranteed. These are guaranteed rights in Article 1, Section 19 of the California Constitution. Now, I'm going to give a quick example of what it looks like in real life. Let's say there's a public entity that wants to build a park. There's a vacant lot. The public entity goes to the park and says, I want to, goes to the property owner and offers the property owner or property owners money for it. The sale is made, pays the fair market value for the land, the park is taken, and the park building may begin by the public entity. Now, if during that construction, a bulldozer knocks over an adjacent fence onto an adjacent property owner's land, or pours dirt onto the adjacent property owner's land, then that adjacent property owner can say, hey, wait a minute, your public project, the public park, owes me money. You have taken or damaged my property. And that is how inverse condemnation arises. Now, if a person, a property owner, wants to bring a claim in inverse condemnation, they must prove three things. First, that a public entity, two, took or damaged their property, three, for a public use. Those are the three things that are required to make the claim for inverse condemnation. That's it. You prove that, you prove inverse condemnation. Now, we come to the interesting circumstance of the privately held utility. In 1993, there was some fires down in Southern California, the Mill Creek fires. And what happened there is there were power lines that were knocked down that were owned by SoCal Edison. Those power lines fell and started a fire and burned some property. Those property owners brought a lawsuit in inverse condemnation. The lead on that property owner, was Barnum, Mr. Barnum. So he brings this suit down in the 4th District, that San Diego Riverside area. And he comes in with this suit and he sues for inverse condemnation. The first thing SoCal Edison says is, we're out. You can't sue us for inverse condemnation because you fail on your first prong. We are not a public entity, so you can't sue us for this. But the 4th District Court disagreed. And the appellate court down there said, no, because privately held utilities enjoy monopolies or quasi-monopolies in providing the services to the people in their area, they are to be treated like, just exactly like public entities for the purposes of inverse condemnation. And they said the reason for this was that it was unfair to foist the burden or the cost of providing electrical services that millions of people enjoy onto just those few property owners who suffered the burn damage. Now, fast forward to 2012, and we have a second district case. That's the Los Angeles area. Down here, this is another SoCal Edison case. They're up again to bat. What happens is a big bird comes between two charged power lines, gets between, zap, comes down through there, electricity pours down through the ground into some underground trenching that Pacific Bell has wiring and cabling in, destroys it. So what does Pacific Bell do? They sue SoCal Edison. They say, SoCal Edison, you owe us in inverse condemnation. Well, what happens? SoCal Edison says, let's go back to the Barnum case. They got it wrong. Well, the second district disagrees. They say, actually, they follow Barnum exactly. They say SoCal Edison is a monopoly, enjoys monopoly rights, and because of that, and because of the same reason, because they want to protect owners whose property is damaged, should not bear the disproportionate costs of the public improvement. For that same reason, they say, no, we're going to find that you can stand liability, you can be liable in inverse condemnation. So this time, SCE says, wait a minute, this isn't fair because we're not like another public entity. Public entities can go to the taxpayers and can raise the rates to everyone, and then that pays for the cost of the public improvement. But we can't do that. SCE says we have to go to the Public Utilities Commission, the PUC, and ask for permission. And if we can't get that permission, we don't get it, we're bearing that cost, and that's not fair. So the second district considers this argument, but rejects it. And they say the most important thing is that SCE was enjoying the monopoly. It is the monopoly that gives them that gives them special privileges, and that they don't have the right to be treated like another private company. So they were very firm about this. They even drop a footnote, at footnote 6 in this case, and what they say there is, even if the legislature were to pass a law that said they could not recoup money from their customers, even then, that would not be enough to take them out of the inverse condemnation regime. And that is a status of the brief summary of the law of inverse condemnation as applied to privately held utility companies. Now, we got, of course, this is a very minor summary, and I'll be available if you have further questions as the day goes on.
And thank you. And just to clarify, this also applies to our publicly owned utilities, correct?
Yes, exactly. Yes. In fact, the court said that specifically in the Pacific Bell case. They said that one of the reasons was that they made the decision is they could not differentiate. They couldn't see how they could differentiate between a publicly held utility being held liable in inverse condemnation when a privately held utility would not be, for essentially what would be the same thing.
Yes, please, Commissioner Khan.
This is California Supreme Court. They haven't ruled on this, correct?
That is correct. These are two separate appellate court decisions.
Okay, and how many appellate courts are there?
There are 6 appellate courts.
And if one of the appellate courts who hasn't ruled on this have this issue, are they bound by that, or are they allowed to review that de novo?
Each appellate court may determine this matter for themselves individually.
So not only is this not binding on the Supreme Court, it's not even binding on any district except the 2 that have ruled on it?
Absolutely, that is correct.
Thank you.
Thank you. We appreciate you being here and ask you to take your seat. But if we have clarifying questions, we'll be sure to call you back.
Thank you.
Now let me ask our panel to join us. We have Dan Skopek, Vice President, Regulatory Affairs, San Diego Gas and Electric, Joy Mustache, Senior Attorney, Sacramento Municipal Utility District, Rex Frazier, President, Personal Insurance Federation of California, and Kara Martinson, Senior Legislative Representative, Federal Affairs Manager, California State Association of Counties. Just for some context, the reason we're talking about this and getting into very quickly a legal discussion is that one of the key issues that we need to be aware of or think about is who is liable and what does liability currently look like. And there are various stakeholders who have different views, again, on the interpretation of this doctrine. And we're looking to hear your feedback, but as well as what is the implication of the doctrine as it is, as we think about ultimately what we can do to manage liabilities and costs, particularly associated with utility infrastructure. So Mr. Johnson, what order are we going with the order of the agenda?
Yes.
And we've asked everyone to give 5 minutes of intro comments, and then we'll open it up for questions and discussion. Mr. Skopek, please take it away.
Thank you. Good afternoon, Commissioners. My name is Dan Skopek. I am the Vice President of Regulatory Affairs for San Diego Gas and Electric. We appreciate the opportunity to speak before the Commission today about wildfire liability. As you may be aware, SDG&E was the first utility to experience the true peril that inverse condemnation places upon electric utilities. In 2007, Southern California experienced an extremely powerful Santa Ana event. It fueled more than a dozen destructive wildfires throughout the entire region. And CAL FIRE, I would note, and Cal OES and the U.S. Forest Service put out a comprehensive report about the causes and some recommendations around that fire. I don't have time to review that, but I would commend that to the Commission. The ignition of 3 of those fires, the Witch, the Wajito, and the Rice Fire, were attributed to San Diego Gas and Electric's power lines. Asserting inverse condemnation, property owners, local governments, CAL FIRE, and insurance companies sued SDG&E for approximately $5.6 billion in claims. SDG&E settled those lawsuits, paying out a total of $2.4 billion in settlement costs and legal fees. SDG&E settled these lawsuits despite strong evidence to the fact that we were not negligent and had operated our system safely and prudently. But as you just heard, that is not the standard under inverse condemnation. The standard is strict liability, giving SDG&E little to no option but to settle those cases as reasonably as possible. At the time of our 2007 wildfires, SDG&E carried approximately $1.1 billion in insurance. We were also able to achieve reimbursements totaling about $824 million from a cable company and several contractors. That left approximately $500 million in liability. As you just heard about the legal principle of inverse condemnation, the theory that the utility should be held strictly liable regardless of fault because it can pass those costs on to its customers, just like a government entity would pass it on to taxpayers. So subsequently, SDG&E filed for recovery of these costs from our state and federal regulator, the CPUC at the state and the Federal Energy Regulatory Commission, or FERC, at the federal level. Over several decisions, FERC authorized recovery of all the costs associated with our transmission system. In approving recovery, FERC stated, under California law, SDG&E would likely have been responsible for such costs regardless of fault. Unfortunately, in 2017, the CPUC came to the exact opposite conclusion in response to our filing known as the Wildfire Expense Memorandum Account, or WEMA. In its decision, the CPUC declared that inverse condemnation doesn't have an impact or relevance to its jurisdictional responsibility. It went on to declare that SDG&E had not prudently operated its system, and it used a hindsight review to establish what we considered a perfection standard. I will note, however, that President Picker has frequently commented on the flaws in the application of inverse condemnation to investor-owned utilities, and upon voting for the WEMA decision, he said that the question of SDG&E's prudence was a close call, and it led him to question the rigidity of the CPUC's own prudency standard, and asked the legislature to consider giving the CPUC the tools to do a more nuanced assessment of fault. It was this vote, combined with the wildfires of 2017 and 2018, that led to the financial crisis that caused one utility to file bankruptcy and the other two IOUs to suffer multiple rating downgrades. So where do we stand today? This untenable financial and regulatory situation led to the reforms enacted by the legislature last year in SB 901. And we don't have time to review that whole bill, but I think you're quite familiar with it. But I will say, we appreciate the steps that the legislature took in SB 901, but unfortunately it did not go far enough. There's more that needs to be done. As may have been noted, inverse condemnation reform was not included in SB 901. As a consequence, investors assume that the IOUs will continue to be strictly liable under inverse condemnation for wildfires linked to our equipment. And in light of the CPUC's WEMA decision, investors will also assume that the CPUC will not permit cost recovery of wildfire costs, which means these costs will be borne by investors. The status quo with respect to wildfire liabilities has seriously harmed the IOU's credit worthiness. PG&E's bankruptcy is the most glaring example of this loss of access to capital markets. Now, I will note that SDG&E's equipment has not started any of the catastrophic wildfires that the state has experienced in 2017 and 2018. Nevertheless, like the other IOUs, SDG&E's credit rating has suffered downgrades in both 2018 and 2019 because of the existing liability reform. And I was going to cite some of the rating agencies' concerns, but in the interest of time, I passed out a copy of those reports for you, S&P, Moody's, and Fitch. I also note that increased capital costs are harmful to both IOUs and their customers, since the cost of capital is passed on to customers through rates. And this will certainly be an issue in the upcoming cost of capital proceeding at the PUC, which takes place later this year. So in conclusion, I want to stress the urgent need for further action to build off of the reforms in SB 901. And we would make the following recommendations. First, the issue of inverse condemnation or the issue of utility cost recovery is really at the heart of this matter. Either the state needs to reform inverse condemnation, or it needs to establish a clear path for utilities to recover liability costs when they are prudent operators. That's a key word, prudent operator. The determination of a prudent operator needs to be established in statute and approved by the PUC up front. The utility should be deemed prudent if it's in substantial compliance with its wildfire management plan, which these are the plans that were required in SB 901. Substantial compliance means the utility has met every reasonable objective of its wildfire management plan. Gross negligence, willful misconduct, and a pattern of non-compliance is not substantial compliance. We understand that. I should also note that when a utility is out of compliance with PUC rules, the commission has broad authority to penalize it, and that authority was actually extended in SB 901. Recommendation number 2, a statewide wildfire insurance fund should be established to socialize the cost of wildfire liability broadly. Such a fund should include investor-owned utilities and municipal utilities. The fund should operate on top of utilities insurance coverage. And utilities should contribute to that fund based on their relative risk profile, factoring in their service territory size, their fire risk, as well as the investments and programs that they've made to mitigate catastrophic wildfires. And number 3, utilities should be able to access the wildfire fund or securitize their liabilities through a dedicated break component prior to and after the fact reasonableness review. This is essential to avoid future liquidity crisis that could lead to bankruptcy. With that, I'll pause and look forward to your questions.
Thank you. Can we do the whole panel and then have a discussion, or do you have a clarifying question?
Well, I do, actually.
Okay.
If you don't mind. I'd like to ask you 2 questions, and I want to ask each panelist the same question. And that is, you say you want reform, but you don't tell us what reform. I'd like to know what reform specifically that you think we should make. And I'm not interested in now in the passing the costs on to somebody else aspect of this through the prudency. I want to know what reform to inverse you think we should advocate. And second of all, what mechanism should that reform take? Is that an act by legislature, a constitutional amendment? What's the mechanism? So those 2 questions.
So, as I said, we believe you can either perform inverse condemnation or you can address cost recovery.
I understand that. I want to know what the defense of my first question is. How do you think we should reform it? And what's the mechanism?
Okay. So, inverse condemnation is based on the California Constitution. So a complete repeal of inverse condemnation, many legal scholars believe, would take a constitutional amendment. But a reform to it that is less than a complete repeal, that indicates where entities like investor-owned utilities would be liable and where they wouldn't be, and a standard that is something lower than inverse condemnation, we believe could be done in statute. So a reasonable standard or a prudency standard could be put into place in statute. That would be a standard lower than inverse condemnation.
Thank you. Our next speaker, Joy Masache, welcome.
Yes, thank you for the opportunity to speak with you today. And my name is Joy Masache, and I am a senior attorney with SMUD. SMUD is the nation's 6th largest community-owned, not-for-profit electric service provider, the 2nd largest in California. We serve the 1.5 million residents in Sacramento County and small adjoining portions of Placer and Yolo counties. We also operate our Upper American River Hydroelectric Project, or the UARP, in El Dorado County within the CPUC's High Fire Threat District. As we come to grips with the new normal of our changing climate, including all the unprecedented wildfires, we must all do more to keep our communities safe. And SMUD has and continues to implement more expansive wildfire prevention plans and to strengthen construction, maintenance, and operation of its electrical equipment throughout the service area and the UARP. SMUD and other utilities should remain liable for wildfire costs when we're at fault. We feel that's only fair. However, utilities shouldn't be held strictly liable for wildfire damages when the utility acted responsibly and prudently and has met all the safety, inspection, and maintenance standards. We feel the current system is unsustainable in the face of increasingly severe and frequent weather events. Concerns over the liability structure have been repeatedly voiced by the credit rating agencies, as was mentioned, and by many others. Updating the liability standard is essential to ensure that California's utilities can continue to provide affordable and reliable service, as well as to make investments in programs designed to achieve California's climate goals. And while we must not lose sight of the personal devastation inflicted on each and every member of a community that is impacted by a wildfire, we must also be mindful of the inequities that result from shifting all the costs to utilities regardless of fault. Unlike the investor-owned utilities, publicly owned utilities like SMUD don't have shareholders to bear any of the costs and the damages inflicted by a catastrophic fire. Our only recourse is to collect from our customers, and those costs can have a disproportionate impact on customers least likely to afford it. Assuming the current financing options continue to be available, a major wildfire reaching billions in damage and liability could cause SMUD's electric rates to increase in the neighborhood of 25%. Small POUs could be impacted even more severely. So while SMUD retains wildfire insurance to protect against the financial impact of a catastrophic fire, strict liability for damages has caused insurance rates to skyrocket. Our wildfire insurance costs for this year are almost 4 times higher than the prior year for limited amounts of additional coverage. Higher insurance costs and paying claims when not at fault will divert utility investment away from meeting our aggressive renewable energy and GHG reduction goals. And now more than ever, as the wildfires wreak havoc on the environment, we must depend on a reliable electric system to meet our clean air goals. So we feel like California must act swiftly and thoughtfully to address this urgent matter. SMUD's elected board of directors takes this seriously. It has adopted a strategic directive that SMUD will maintain the electric system in good repair and make necessary upgrades to maintain load serving capability and meet regulatory standards. We are on target to complete our wildfire mitigation plan prior to SB 901's December 31 deadline. And SMUD's fire prevention efforts include many of the same elements we have heard from the investor-owned utilities, such as expanded vegetation management activities using advanced technologies, regular ground and area patrols, ignition-resistant construction, procedures for deactivating reclosers and de-energizing power lines to address severe weather, improving situational awareness, and continued coordination and collaboration with our local agencies and first responders. We are participating in ongoing discussions regarding potential financing and funding approaches that have been mentioned, and I'm sure will be continued to be discussed later on in the session. And this includes the current Assembly Bill 235. We feel that any such approach would have to ensure that if our ratepayers are to contribute to such funding, the utility contribution levels are based on risk as well as size, and that a proportionate benefit is available if needed. Another concern is that an occurrence such as we have seen over the last couple of years could deplete any shared fund, particularly if there are multiple events throughout the state within a short period of time. We believe that there is no single answer here, but rather action on multiple fronts is required. A continued focus on forest and vegetation management, implementation of cost-effective prevention and response programs, prompt availability of wildfire investigation findings that can inform the development of best practices going forward. Support for public education and emergency response, and to the point of today's discussion, an equitable apportionment of wildfire risk. We look forward to working with the Commission on all of these issues.
Yes,
Just
so
jump right
any
into
specific, I mean, we'll just do that with the end of everyone's, any specific recommendations right now you want to offer, and if so, what is the venue? And we'll have the opportunity to discuss that as a group as well.
Sure, and I think our answer would be aligned with the answer that you heard from the prior panelists. Last year, there was a proposal that offered some approaches to the reform, and I believe that that is something that we can use to work off of. I think that there, as was discussed, some options to make some advances in the legislature, short of a constitutional amendment.
Just one follow-up. Do you think public and private should be treated differently, or do you think there should be one amendment?
In true loyalty fashion, I'm going to have to say it depends, I think, on the circumstances, but in general, I would say that both investor and publicly owned utilities would be treated similarly when it comes to a liability perspective.
Ms. Martinson, do you want to just go next?
Sure. Great. Thank you, Commissioners. My name is Kara Martinson, and I am the Senior Legislative Representative with the California State Association of Counties, and I'm going to focus my remarks today, obviously on the local government perspective, but also will be representing, I think, the perspective of victims that we represent within our communities. And I'm actually encouraged to hear the comments by while we, I think, differ on a key component. I'll start actually with answering Commissioner Khan's question. We don't believe that you can change inverse short of a constitutional amendment, but we do believe there are ways to build on our current liability structure that will increase certainty for utilities and protect ratepayers and ultimately protect victims as well. So CSAC was very engaged, as I'm sure you're aware, in the passage of SB 901, and we are committed to its successful implementation. But as I just mentioned, I do think that there are a number of ways that we can improve upon it, and really the core is to improve the safety of our communities, because we will continue to experience catastrophic wildfire in California. But our interest really has always been squarely focused on our communities and our residents and our ability to recover and rebuild from these disasters and ensure that our communities are safer and more resilient moving forward. We do want to be clear, though, however, in this study of our current liability laws, that we do feel that the current legal construct of inverse condemnation is really the critical underpinning that helps to facilitate the efficient resolution for victims in the aftermath of a utility-caused wildfire. And while this is the main tenet of the system, we do, as I mentioned, believe there are ways to improve upon that process, the regulation of the PUC, and also the overall structure to ensure really three main points: that victims are swiftly compensated after utility-caused wildfires. There remains a strong incentive, which we believe IC brings to the table for safety, and that there is a clear path moving forward for how you determine cost apportionment, what can be passed on to ratepayers and what cannot be. And we do feel that liability and negligence play a key role in that discussion. So just from the local government perspective and why we feel strongly about IC, again, we think it works to provide that strong safety incentive for utilities, also local governments, as we're subject to this clause as well, to take action and invest in critical measures to protect ratepayers and residents. I think we have a great example of that in SDG&E. After their 2007 wildfires, they committed a tremendous amount of resources, and we've actually gone down and visited their weather center to change their corporate culture to focus on safety, to make sure that they're not liable in the future for excess liability and costs from a utility-caused wildfire. So we do see that it does in certain circumstances work. And it, again, provides that incentive to prioritize programs and policies that put safety first, if really for no other reason than you'll be liable otherwise. Secondly, local governments and private citizens use inverse as a legal standard to bring these companies to the table for swift resolution to settle claims rather than languish in court under negligence suits. Homeowners have a very limited time frame associated with their alternative living expenses, 1, sometimes 2 years, and it's really critical that homeowners and victims can come to resolution and settle in order to rebuild and recover. And without this standing in place and reimbursement from responsible IOUs, really the overwhelming majority of homeowners will not be able to rebuild. And this not only impacts private property owners, but also a local government's ability to regain our tax base and really move forward as a community. So that swift resolution, which IC brings, is critically important. And then specifically from the local government perspective, after an incident when our property is damaged, we used IC as well. But we do receive obviously a lot of assistance from state and federal programs. But oftentimes the costs run to the hundreds of millions of dollars, because there's a number of categories which are just categorically not covered by state and local government. And the local cost share itself can be millions of dollars as well. So we're talking about parks, roads, sidewalks, watershed restoration, water contamination, and a number of other things. And these are just examples of the uncovered taxpayer losses in the event of a disaster. So really that's kind of our key thought for why keeping this legal standard in place and why it's important. And as we already heard, the Conference Committee on 901 debated this quite a bit last year, and we believe that they did not change inverse condemnation because it really doesn't achieve the problem we're trying to solve here, which is greater certainty. 901 was successful in creating enhanced safety planning measures for the utilities, which we talked about previously. It provided a tool to PG&E to securitize their debt. But we do think that it left a few things off the table, and I think we actually are in somewhat of agreement on what that was. The bill did not clarify the process at the PUC for what debt can be passed to ratepayers, and really what is considered or what is defined as a prudent manager standard. It provided additional criteria to the PUC, but it didn't give them that certainty that they had been requesting. In addition to that, we believe there are a number of other factors that this commission can consider when thinking about how to socialize the cost of wildfire, but really we want to characterize these in what can keep our communities safer, what can protect victims, and then ultimately provide that greater certainty, because the credit markets and the fiscal health of our utilities are important to us, as well as we want to keep the lights on across California. But given the frequency and the greater cost of wildfires, I think insurance coverage is something that we all need to think about. Local governments have excess liability coverage. Utilities obviously have policies, and the state is now even contemplating how to insure their general fund or their E-fund. So increased coverage across all fronts, including at the homeowner level, which starts with education, I believe, can really go to a long way to protect excess liability, and then that ultimate pass-through potentially to the ratepayer if those actions are deemed prudent, depending on what that definition is. So we also believe, and I think it's a part of your charge, that the concept of a catastrophic wildfire fund has merits. Obviously, the details are very important there. Who can access that fund at what time and for what purpose? But investments from the utilities, from the state's general fund, or perhaps a cap and trade fund, can provide sort of that initial upfront capital, really to start off the fund, but also to simplify the process for victims, because that swift compensation after losses at the individual level is critically important. So those are just a few ideas we have. And then also I think one thing that we're thinking through ourselves at the local level is if, we do believe it's important to understand what prudency is, and negligence obviously plays a role in that. But if actions were prudent, we have inverse condemnation in place, and there's the potential for that cost to be passed on to ratepayers. How do we socialize that cost? Because as the cost of wildfires increase and we experience greater frequencies of these events, that's going to have a tremendous impact on ratepayers as well. So if an event happens in just PG&E territory, can it be socialized across all of California? These are things we're trying to think through and assess sort of what the impacts would be on our communities. And these are some ideas we have. We look forward to this discussion, and we really appreciate the opportunity to provide testimony today.
Thank you. Mr. Frazier.
Good afternoon, Commissioners. Thank you. My name is Rex Frazier. I'm the president of the Personal Insurance Federation of California. We represent admitted market insurers on residential property insurance issues. The admitted market, which means insurers voluntarily writing insurance after receiving a customer application, is presently insuring over 98% of the approximately 11.5 million insured structures in California. The admitted market also provides a financial backstop for high-risk properties, known as the California Fair Plan. The Fair Plan provides property owners guaranteed access to fire insurance. All admitted homeowners insurers are required to be members of the Fair Plan as a condition for doing business in California. And the Fair Plan operates without any state financial support. If the FAIR Plan is short of funds, it will assess admitted insurers as required. Of the 123,000 properties insured by the FAIR Plan, only 34,000 of them are located in brush areas with medium or extreme brush exposure. The 18,000 homes not served by the admitted insurers, either directly or indirectly through the FAIR Plan, are served by the non-admitted market. These three elements, the admitted market, the FAIR Plan, and non-admitted market, collectively comprise the private property insurance system in California. And following a major fire, this system executes a massive claims response, which typically involves bringing hundreds of people from across the country who are willing to move to California for months, and sometimes in excess of a year, to serve the people impacted by the fires. When a fire is caused by a third party, property insurers begin the claims payment process as well as the subrogation process. Subrogation is a common process where both private and government payors answer the call of people to whom they owe a duty, and then seek to recover those payments from the party causing the damage. This happens every day in the auto insurance industry, where a customer makes claim with his or her collision insurer, and then that insurer seeks to recover from the at-fault driver's liability insurance. The Medi-Cal system also does this every day, paying for indigent health care, and then seeking recovery from those who caused the harm, which is oftentimes an insured driver. This subrogation process applies equally on the rare occasion that a utility causes a fire. Wildfire plaintiffs, including subrogating insurers, have repeatedly settled claims arising from utility-caused fires. This practice had never received significant public attention until late 2017. After the California Public Utilities Commission found that San Diego Gas and Electric did not reasonably operate its facilities prior to its 2007 wildfires, and as a result denied SDG&E's application to socialize across its ratepayers the remaining fire costs that exceeded its commercial insurance recoveries. While the 2018 legislative session prominently featured a debate about whether the takings clause should apply to industrial utilities, that debate obscured the real problem facing the IOUs, which is how the 2017 PUC decision disrupted the widely held market assumption.
Is not available at this time. Please try your call again later. Announcement 1, switch 2, dash 4.
Particularly when that PUC decision was so close in time to the massive potential liabilities accruing after the Tubbs fire in Santa Rosa. For the first time, investors realized that a California IOU could face a large unfunded liability if the PUC determined after the fact that an IOU imprudently caused the damages. This risk exists whether or not plaintiffs sue using constitutional rights to an inverse condemnation claim or more traditional causes of action such as negligence. In 2018, we urged parties to focus on developing brighter line PUC standards for when and how an IOU should be permitted to socialize its unfunded liabilities. Every regulated company deserves a clear legal standard for evaluating its conduct. Such standards allow managers to develop proper goals and supervise towards achieving them. The standards applied to SDG&E in 2017 left them claiming unfair surprise, and this surprise rippled across the investor community. While SB 901 included changes to the process for determining prudent behavior, it retained much more ambiguity than is present in a more traditional negligence analysis. An additional concept of how to better socialize utility wildfire liabilities is the emerging consideration of a utility excess liability fund. And we encourage serious deliberation of such a funding mechanism. While there are many details to such an approach, the concept is straightforward. After determining first a utility's self-insured retention, meaning the fire risk it retains, and second, the preconditions necessary for claiming to a catastrophic pool, such as compliance with the wildfire mitigation plan, a utility could tap pooled funds to pay for catastrophic liabilities it causes. There are many options for how to capitalize such a fund and many conversations occurring outside of this forum. We remain committed to being an active participant in these discussions and responding to the governor's challenge to develop the framework for a solution in the very near future. Thank you very much.
Thank you. And I appreciate you all noting that this is a topic that was part of legislative hearings last year. I think unfortunately over a 6-month period, we've had a few data points that continue to help inform our thinking both about fires as well as utility financial health. And so welcome your insights again today. Let me start with one or two questions. I'm sure my fellow commissioners will have several, and so we'll just take turns. Ms. Martinson, two questions for you. You noted that, and I can appreciate that, the inverse condemnation doctrine allows for the efficient resolution of wildfire victim claims. I welcome your thoughts about whether it is still efficient given the potential for bankruptcy that we now see as possible. And then my second question is, this commission is focused on the equitable allocation of costs. So can you explain why the current doctrine is equitable as well as efficient?
Sure. On the first point, obviously bankruptcy is not, or Chapter 11 is not a situation victims or utilities want to find themselves in. It's my understanding from talking to our councils, of which I'm not one of them, that negotiations for settlement continue while they're also talking about restructuring. So those processes can move simultaneously. I also think, obviously with this commission in place and discussion still continuing, that excuse me, certainty is an important part for utilities to find. So it sounds like these are moving sort of on track together. It doesn't speed up the process, and I do think that it has the potential to greatly slow it down. But obviously nobody wants to find themselves in the scenario that we're in now. On your second point, I do think that there is a potential, as I mentioned, to greater socialize the costs associated with liability under IC, but that depends, I think, on really what the nature of the liability is. If the liability was just strictly strict liability, there was a determination that the utility acted reasonably and prudently, then those costs can be socialized across its territory. I think that the PUC currently has the ability to do that. I'm not sure if they have, or they feel that they do, but we feel that the criteria is there. They've throughout the discussions last year mentioned that they wanted additional criteria and they wanted additional guidance to make that determination. But the potential to socialize those costs, depending on the type of liability, currently exists in our opinion.
Yes, let me just wrap up this point though, which is, so if I'm understanding you correctly, your preference is for a mechanism that allows as comprehensive a socialization as cost as possible. It's not necessarily those costs need to be socialized to ratepayers. Would that be fair?
We want the ability for the utilities to have certainty when it comes to cost, but we feel very strongly that the actions that led to the event are important in that determination and in that determination or that ability to have certainty as well. If there is negligence or if there is determination by their regulators that they did not act reasonably and prudently, that has an ability to impact that certainty, and we think that that's okay.
Mr. Connie, you have a follow-up?
Yeah, I have two follow-ups. The first question I'd like to ask about, I don't understand your efficiency argument. Under the current IC law, if a spaceship drops something from the sky onto a utility line and the utility line burns up a community, everybody who bought homeowners insurance and collected on their homeowners insurance, the insurance companies can then go get reimbursement for all the costs from the utility for the cost of the spaceship falling on the line, despite the fact that they already had insurance. What's efficient about allowing people who bought insurance for their house burning down, collecting it then against the utility? What's efficient about that?
I think we're talking primarily about folks that are underinsured or not insured.
But that's not the way it's working. The way it works under IC, the way it works is if you have insurance and the spaceship caused the utility line to cause the fire, the insurance company gets to get the money back from the utility. I don't understand why you think that's sufficient.
I think my point about the efficiency is that, and sort of the speed at which claims are settled, is that it's a strict legal standard, so it brings folks to the table to negotiate rather than deliberate in court under different circumstances.
Okay, at least I'm gonna need your good thinking of the counties about why it makes any sense or is efficient in a strict liability context for insurance companies to be reimbursed. That's the first question I have. Second question I have is your comment about equitability. You recognize that our utilities don't have overlapping jurisdiction. They're separate, right? And to take my hypothetical for a second, the spaceship drops something down and it hits a PG&E line, okay? But the PG&E line is on the border with SoCal Edison, and it burns down the entire Edison community. You with me so far? In that situation, as I understand it, PG&E's ratepayers or PG&E has to pay because they're the utility that caused it, right? Why is that fair?
Well, I think as I mentioned sort of in some of my final points, that as we're interested and open to how we can more equitably socialize some of those costs across all of California. And this is an issue that CSAC and our local government partners, and frankly, I think all folks that are working on this issue in the Capitol are trying to figure out. It's not a straightforward issue. I think the issue of catastrophic wildfire is of significance statewide. And so if we are to create a fund, potentially, which we do believe will go to help the efficiency aspect for claims, pass-through of costs associated with prudent behavior, there's an argument to be made that pass-through can then be more equitably socialized across a greater territory, regardless of which IOU caused the fire.
Right, but until you fix that, the way I see works now, which you're advocating for leaving it, the way it works is the ratepayers of the utility pay regardless of who's harmed or what happens. And do you think that's equitable?
Well, as I mentioned, I think that we are interested in keeping the legal standard in place and building upon it to make it more equitable.
Okay, I'm going to ask you to help me. I don't see how you leave it in place and make it more equitable. It seems like inherent in its construct is maybe the equitability problem. And I'm having trouble figuring, that was why I asked the first question, trying to figure out how you leave some of it in place and yet get equitable. And if you could help me do that, that would be wonderful. Thank you.
And I'll ask just a slight version of that question. I know
Commissioner Nava has a point, and this is for all of you to respond to when you get your chance to respond, which is, given that you all expressed some interest in a fund that would have contributions from different entities, what does it matter whether inverse condemnation interpretation stays the same or not? How does then your approach to it affect the ability to move forward with that fund?
I think it goes back to really all of our comments with regard to what a prudent manager standard is. We feel that negligence is something that shouldn't be socialized, essentially. And so that's why keeping IC in place is very important to us.
Thank you, I appreciate that. And we're going to turn to Commissioner Nava, and I will say though, Mr. Skopek, the idea of negligence has been mentioned a couple of times, and you can clarify about whether your proposal would apply for cases where the utility is negligent, because I did not realize that was under consideration. Commissioner Nava.
Yeah, look, I think we all understand that inverse condemnation is a really big stick. And that's basically what the counties is saying, and that the stick in this particular case, it bears heavy on the utilities. But what I'm struck by is the basis for applying inverse condemnation on the utilities is the idea of a monopoly. And that since you have a monopoly, then you can go to the PUC and theoretically recover those costs, or they're passed on to the ratepayer. But have we had any sort of conversation about how that makes sense given how the energy markets are changing? So if, for example, utilities decide that they don't want to procure energy, the monopoly was that you got the energy, you sold it, you put it in the lines, and so everybody benefited from it. You needed it for economic development and growth and all the rest of that. Is that likely to be impacted by the changes in the energy market that we see, where we have communities developing their own sources of energy, but then they need the transmission and the utilities to move it from one place to another? And does that still constitute a monopoly?
It's a good question, because it is very confusing what's happening in the California energy environment today. You're right that many entities, community choice aggregators, and direct access providers are starting to provide what we call commodity service to customers to a much larger extent. But regardless of whether there's a CCA or a direct access provider in our service territory, we still maintain the transmission and distribution grid. We still bill for that, and so that we would still bear the liability. Those entities that provide the commodity service don't carry that liability, at least under the current construct. I believe, well, I won't associate it with a particular commissioner, but I believe one of the commissioners of the PUC mentioned this point at a recent public hearing, that maybe the CCA should bear some of the liability, but currently they wouldn't.
All right, thank you.
Commissioner Rock?
Thanks. So this is maybe a question for multiple folks on the panel. I'm interested in hearing your response. Let's say, hypothetically, that the legislature passed a law that modified the application of inverse condemnation to investor-owned and perhaps publicly owned utilities. It's my presumption that the day after that happened, or perhaps when there was a fire and the new rule was applied, there would be lawsuits, perhaps from people sitting in front of me, perhaps from other people. And those lawsuits would result in protracted litigation around the issue of what was or was not constitutional for the legislature to do. How would that impact the investment certainty that we want to create for the utilities and for the fire victims? Is it unimportant? Does it lower the value of an inverse condemnation modification or not?
I'm sure all of us probably want to weigh in on that. It is important, but, and this is speaking also to Commissioner Peterman's point, if inverse condemnation were eliminated, we would still be liable if we were found negligent, and negligence is still a high standard. So, I did want to comment on the point of utility incentive. We still have a very, very high incentive to never start another fire again because of that. So if inverse condemnation were modified, it may create a new standard. It could potentially diminish some of the costs of the current system, but you would still have lawsuits and you would still be potentially liable depending on whether you're negligent. Now, if in your scenario a law was passed and lawsuits were filed, then the claimants against any utility during a fire would probably be held up and delayed while those lawsuits about the constitutionality of that law had to take place. So it would create some uncertainty for a period of time, I believe, until that was settled. But I still think that whether inverse condemnation is repealed or not, we would have a negligence standard, we would still be held to a very high standard, and that's why some of these other issues that we've been talking about today, prudent manager, cost recovery, insurance fund, are still important. I wouldn't remove any of those from consideration regardless of what happens to inverse condemnation.
And I would tend to agree with the comments from Mr. Skopak. There's still liability standards and there's still costs to ratepayers, regardless of whether the strict liability is applied, or you're looking at a negligence standard, or you're accessing a fund of financing that has to be repaid at some point.
I don't think changing inverse would provide any certainty, and we would end up in court. I think a legal standard of strict liability versus a negligent standard, one is very simple compared to the other. And the other issue is that oftentimes when victims bring suit against utilities, they settle because that legal standard is very clear, and they don't have the resources to engage in litigation, which takes time and expense to prove negligence in court.
Commissioner Wara, to directly respond, of course, every plaintiff group that presently enjoys the ability to file a cause of action for inverse condemnation would be in court the next day. There's no doubt about it. It's a constitutional right as defined by the appellate districts where these service territories are, regardless of whether there's 6 or whatever. And of course, plaintiff groups, if a court tells them they have a constitutional right that they can exert, they're going to do so. And so the notion that folks would just sit back and say, sure, let's give away a constitutional right, it's only for property, no big deal. Well, of course they're going to seek to protect that, just as anybody would protect any constitutional right they felt entitled to, whether that would be freedom of speech or right to privacy or any other constitutional right. Just because it is related to private property, it doesn't mean it's any less worthy of protection. So of course, so we spent all of last year having just this sense or such back and forth, and ultimately on legal grounds, I believe the legislature was convinced it's a waste of time to attempt to do this through the legislature. On fairness grounds, there simply was no interest in the legislature changing this legal standard. And we wasted a lot of time last year instead of starting to focus on what caused this. Inverse condemnation did not cause the present situation because it's been around for 20 years. So why didn't we have these problems 20 years ago? The problem was that SDG&E was caught by surprise because they had a standard applied to them that they didn't know existed. And then we had Tubbs. And then all of a sudden, there's this worry that the investors have about potentially springing unlimited liability that they didn't have a plan to fund. And that's the solution that we need to start focusing on. And just going back and forth about inverse takes us nowhere other than arguing. And the governor has told us, let's try to do this quickly before Moody's or S&P decides they want to take further steps against Edison and SDG&E. And if all we do is argue about inverse, then we're not going to be really helping the very IOUs we say we're concerned about. What we need to do is to develop a clear standard where they know how they can fund their liabilities when they're prudent or not. And certainly, if we're going to continue to have large fires, some form of excess liability fund.
I'm going to follow up here with Mr. Skopek, because Mr. Frazier, you said a lot of things on behalf of Mr. Skopek. And let me see if Mr. Skopek agrees with those things. And I have to make 2 points. We have no intention to argue over inverse, but the legislature in 901 did create this commission, and within the scope of that commission is looking at this question. So my sense is there was an interest in taking more time to continue having this discussion. Mr. Skopek, it was mentioned by Mr. Frazier that inverse has been around for 20 years, and that's not the problem. Can you speak to that? I mean, you have a couple, what do you, maybe I'll ask, Ms. Martin's going to answer the question, I think, what she sees as the harm with changing the inverse interpretation. What do you see as the harm in maintaining it?
Well, as I said, maintaining inverse as opposed to a negligence standard probably adds to the cost of the problem. But if you didn't have inverse condemnation and you only had a negligence standard, utilities could still be liable for billions of dollars in damages depending on the circumstances. So again, regardless of whether inverse condemnation is reformed or not, I think we have to address, prudent manager, cost recovery. We have to establish a wildfire fund. Now, I recognize and agree with what Mr. Frazier said about the process last year, and I understand that it's very difficult to change this right. I think there are probably some reasonable reforms that could be considered for inverse condemnation, but I don't want us to believe that that would solve the problem. I will note that, one of the reasons why this hasn't been a problem for 20 years is because no utility has outstripped its insurance. We carried $1.1 billion of insurance and we thought that was a lot. Turned out to be, not as much as it was necessary, and in these recent fires we see it's not anywhere near what's necessary. Is that because of climate change? Is that because of drought? Is that because we have too many houses built in areas that maybe, they shouldn't have been built? I don't know the answer to that, but I know that, the cost of these damages is exceeding the amount of insurance that the utility is able to carry at this time, and so a solution is necessary. And I think all three of the areas that we discussed today, liability reform, prudent manager reform, and insurance fund, are necessary.
Mr. Ward, I don't think you finished your comments, so. Yes, no, yes, I'm turning to you and then Mr. Khan. I interrupted your questioning.
So please do in future. So the other question I have really revolves around this discussion we've had about prudent manager and the relationship between inverse condemnation and the cost recovery process of the commission. And I think of kind of the deemed prudent model as emanating from AB 57 and the approach that was taken to restore the creditworthiness of the utilities after the electricity crisis. And that process, is around procurement and creating greater certainty for procurement and the creditworthiness of utility-signed PPAs. To me, that seems like a very different process to deem prudence about, as compared to the operations in the field of an electric utility that are, where thousands of people are operating across hundreds of thousands of miles of overhead line, in the case of PG&E, for example. And that what works for AB 57 might be a very imperfect fit. And I would just say, having read through the 3 IOU wildfire mitigation plans, one could imagine evaluating the performance of the utility relative to those plans and reaching a conclusion of compliance or not, depending on the ability to monitor and audit, depending on the circumstances that you weigh as more important or not. There's a tremendous amount of discretion there. How do we reduce that discretion in a way that's fair both to ratepayers and to the utilities? So I'm not clear.
Yeah, it's a great question, and it really goes to the heart of this challenge about prudent manager. And I'm glad you brought up AB 57. For those that may not remember, it was one of the key pieces of legislation that broke the back of the wholesale market following the energy crisis and allowed for the utilities to enter into long-term contracts with assurance that they get cost recovery. It's a good analogy. It's not a perfect analogy for the reasons that you cited, because we're not talking about the prudency of contracts. We're talking about the prudency of operations throughout our service territory, which are probably far more complex. But nonetheless, we need a prudency standard that we can rely on, that investors can rely on, that the public can understand, that the utilities have to meet. Now, that may mean that the PUC has to do things a little bit differently. Their typical stance in these positions is an after-the-fact reasonableness review, is the way, as President Picker says, we're an audit agency, and that's not exactly accurate, but, in spirit, I understand his point. That is a more natural position for the regulator to be in, but I don't think we have that luxury anymore, because with that type of after-the-fact reasonable standard, we are left hanging for potentially years with no assurance. And the fact of the matter is we cannot finance that kind of unknown. SDG&E was able to create what's called a regulatory asset, where we were able to indicate to our auditors and to our investors that we had a likelihood of recovery. And so the cost of our liability did not need to be written off. That premise is gone now because of our decision. So without a prudency standard and without the ability to access a wildfire fund or have a dedicated rate component to issue securitized debt, we can't finance the kind of liabilities that could happen from a catastrophic fire. So it is not the natural position for a regulatory agency to have this upfront prudency review, but it's necessary at this moment in time.
Yeah, I'd like to ask a couple of follow-ups on the question of negligence that you've articulated. What happens if SDG&E, we adopt your standard, and SDG&E is negligent and causes a fire that exceeds its ability to pay. Who pays the difference? What happens?
Today,
Today or in your conceptualization? What happens if SDG&E can't pay? Who pays? And just let's take it, you're advocating a negligence standard. So I want to know what you would advocate. What would happen if SDG&E is negligent and nevertheless you couldn't pay and you were bankrupt? What would happen?
just what you described. I mean, if our liabilities exceeded our ability to pay, it would lead to bankruptcy.
Right, but who then would pay? Would no one pay, or does it default, in your view, to the ratepayers?
I think the PG&E bankruptcy will answer that question. That's an unknown.
Okay, that's not what I'm asking. We're here to, I thought we were having a conversation about what you want the future to look like. And so I'm trying to understand what you want the future to look like. What would you like the future to look like if you can't pay negligence? Should the people then not get a recovery, or should someone else pay? Who should pay? And I would appreciate if you didn't answer by saying there should be some magic insurance fund. I'm looking for who actually pays.
Okay, I misunderstood, because when you said if you can't pay, I thought you meant if you had no access to.
No, if you have no assets and it's a negligence standard, what happens? Who pays?
The position that we've advocated is that we would have access to either a wildfire fund or the ability to securitize debt with a dedicated rate component, which means the ability to assess a rate on ratepayers to finance that liability while a reasonableness review is happening. If that reasonableness review determines that the utility was negligent, not prudent, didn't follow its wildfire management plan, didn't substantially comply with that, then the shareholder would be responsible for that.
And suppose the shareholder doesn't have enough money. My question is, what happens when the shareholders run out of money? Yeah, I'm trying to determine whether at the end of that, no one gets paid or somebody else defaults.
I believe that's the situation PG&E is in today, and I think that's the answer to your question. I think that would lead to a bankruptcy.
I understand that. If there's a bankruptcy, does that mean no one pays, or does the ratepayer pay, or does the taxpayer pay?
I can't tell you that, because I don't know what's going to happen in the PG&E bankruptcy. I think there's going to be a process by which all of this is considered, and there's going to be creditor committees, and some people are going to be made whole, and others may not. That bankruptcy process is unclear to me how it would work.
Okay, I'm obviously not very good at asking questions, so I need your help. We're supposed to recommend legislation. If we recommend legislation that says inverse goes away, and it should be a negligence standard, and you should have your prudency standard, we do everything you want. I want to know what happens if you're negligent anyway, and you can't pay. What happens? And I don't want to hear about the PG&E bankruptcy. We have been told PG&E bankruptcy is not our problem. We are trying to figure something that applies to the utilities. What does San Diego Gas and Electric want to happen if it's negligent and it can't pay? The shareholders are bust. What happens?
So the two elements that we've indicated are access to the wildfire fund and access, or the ability to securitize that debt through a dedicated rate component.
I'm assuming you, so securitizing that debt, ratepayers, that's a fancy way of saying the ratepayers pay.
Yeah.
Okay.
Yeah, but you still have the review of your negligence, and if at the end of the day you were determined to be negligent, then the shareholder would have to pay a portion.
I'm assuming San Diego Gas and Electric is gone in that case. In my hypothetical, and what we're seeing in these wildfires is the liability can be humongous. If there's no San Diego Gas and Electric, I'm trying to understand, is the ratepayer paying, or the taxpayer paying, or no one gets paid?
As I understand it, that would lead to bankruptcy.
I know that. After bankruptcy, who pays?
I apparently can't answer your question. I mean, to me, that's the bankruptcy proceeding, and it's unclear to me how that bankruptcy proceeding would play itself out. Sorry, Commissioner.
I wanted to ask a follow-up question, representative from SMUD. So it was asserted that inverse condemnation incentivizes safety. I'd welcome your perspective on that.
I think from a utility perspective, safety and reliability are our jobs, and we don't need the inverse condemnation incentive as it's being represented.
Do you have any comment on that?
Sure, I mentioned it briefly before, but, you know, whether it's inverse condemnation or negligence standard, you know, we could potentially be liable for billions of dollars in damage. And after our 2007 fires, our management made it very clear, we were gonna do everything possible to never start another fire again. And so, Commissioner Peterman, I think you've had the ability to come down to San Diego and see some of the investments that we've made, and I'd be happy to talk about those, and if any of the commissioners would like to visit and see some of those investments. We have made a significant amount of investments to fire harden our system, to improve our situational awareness, to mitigate the impacts of de-energization, which is an important tool to work with our counties and CAL FIRE and fire agencies to be able to fight fires and prevent fires much better. So we have that incentive, whether it's inverse condemnation or not. Remember, you know, we live in the community we serve. We never want to start another fire again. Our franchise is granted by the state of California, and we can lose that franchise if we're not a prudent operator. So, you know, the incentive is very clear, you know, do everything possible to never start another fire again.
I will say your utility has been lauded for you know, pioneering efforts in wildfire prevention and mitigation. Given your experience, do you feel like you're risk-free there?
I'd like to say yes, but unfortunately the answer is no. You know, I don't think we can ever be 100% risk-free. The environment that exists when these Santa Ana winds kick up is very dangerous. And, you know, again, I could list all the mitigation efforts that we've made, but we know that you know, we will never be 100% risk-free. Unfortunately, what that means is we have to start to compromise reliability for safety. And that's what de-energization allows us to do. But, you know, for most of the summer and certainly into the fall, San Diego backcountry is a tinderbox. And so it's, you know, the environment exists for fire all the time in the summer and fall. It's just a matter of, you know, the winds.
Please.
I might just add to that utilities like SMUD and San Diego have long been doing a lot of different activities, efforts, and programs to improve their systems and their safety, because as pointed out, we are responsible to our communities, and we do have the liability regardless, but I think it's more than that. It's responsibility to provide that service. I think we have a lot of examples of activities that utilities such as SMUD have been undertaking for many, many years before this issue has occurred.
Thank you. Well, commissioners, we are up on our hour for this panel. Let me turn to you all to see if you have any final questions for this group. And if there's any public comment specifically on this topic, we welcome it now. Our next panel will be on utility insurance. Commissioner Tom, please.
Yeah, Ms. Martinson, do you agree with the last two comments? Do you think that the public and the private utility are sufficiently incentivized to keep the public safe, or do you think we need the additional protection of inverse condemnation to incentivize them properly?
You know, I think it provides an additional incentive for safety. I think, you know, from my experience and touring the weather center of SDG&E, and that investment happened after 2007 and those wildfires because there was an excess liability. So I think it's clear that that standard does provide incentives. It's not, you know, this is a larger, from our local government perspective, conversation. Fuels management is a key component. We have over 100 dead dyke trees in the Southern Sierra and Ponderosa lands. It takes partnership with the state, with local governments and utilities to address safety, but keeping that legal standard in place does provide extra incentive, from our opinion.
And follow up, do you think that the public entity is more incentivized than the private entity, or do you think they're equally incentivized? Which one of them needs your extra push of the IC more?
Well, obviously, our municipal utilities are a much smaller scale, smaller territories, and so inherently, potentially, feasibly less risk, but the standard applies to both. I do think the difference, obviously, is one is a public entity that does not have shareholders and one does. So those, that difference in structure can potentially influence where investments are made. But again, I think the standard applies equally to both entities.
And just one final question. Mr. Skopek, your utility is held as a standard of somebody who is refutes her contention in that you're doing the best you can, but is in comparison to the other two utilities. Do you have an opinion as to, and you happen to be the one that's been bid, do you have an opinion as to why your utility is react better than purportedly the other two utilities, despite the existence of IC?
Well, I will tell you, as many people have said, wildfire has always been part of California's history. It's always been a part of San Diego's history. But we had two events in the early part of the last decade that I really think changed the thinking in San Diego writ large. The first was the 2003 Cedar Fire, which at the time was the largest in the state. It's obviously been superseded recently. That was not caused by SDG&E's power lines, but it was devastating. And people said that's a 1 in 100 year fire. And, it happens 1 in 100 years. 4 years later, we had the fires that I spoke of earlier, the Witch, the Mojito, the Rice, and several others. And that too was equally devastating. So you had two 1 in a century fires happening within 4 years. That really woke everyone up, whether it was climate change or drought or just this is where we live and this is what the conditions are. We have to approach fire differently. And it wasn't just SDG&E. I think the county of San Diego needed to do a lot of things. The local fire agencies needed to do a lot of things. The land use planners needed to consider a lot of things, but certainly SDG&E recognized that there's a lot of things that we could do to mitigate. Our management was very clear from the moment that fire happened, we never want to be the cause of the fire again. So, to us, inverse condemnation is not the motivation. It's we never want to be responsible for a fire that harms our citizens, burns down our community, and potentially makes us liable for amounts that could bankrupt our company.
Mrs. Skopek, I hate to keep you on the hot seat, but I will note your utility also has the highest residential rates of the investor-owned utilities. And so I know affordability is a general concern for you. Can you speak to how we should be thinking about affordability with the nexus of this strict liability standard?
It's a challenging issue. I certainly appreciate it. And, I thought about something on the way over here. In California, we're a leader on addressing climate change. I think we all recognize that. Most of the emphasis on addressing climate change is about reducing greenhouse gas emissions. I would say probably 90–95% of the time we spend in the state government is focused on that. But there are some agencies that are really focused on climate adaptation. The Resources Agency does a great job on this. The PUC has an open proceeding on it. I know the Air Resources Board and others are looking at climate adaptation. This is an issue of climate adaptation. And climate adaptation is something that many of us thought would come in the matter of the next decade or 2 decades from now. We need to focus on reducing the emissions now, and we can worry about adaptation later. But I think everyone that focused on and studied climate change knew climate adaptation is going to be expensive. It's going to be expensive if we lose the snowpack in the Sierras. It's going to be expensive if we have coastal flooding. It's going to be expensive if we continue to have drought, if we continue to have wildfires, if we can, continue to have heat waves of the kind that we've had. So all of this takes money, and you're absolutely right. It has had an impact on our rates, but relative to the impact of fire, the devastation that causes in our community, we think it's a worthwhile investment.
Thank you. With that, we'll be wrapping up the panel. I will say on this issue of costs and rates, as utilities file comments with us, it is helpful to understand back of the envelope some rate impacts, because I think we wanted to go into these considerations eyes wide open, and we heard from our representative from SMUD about potential 25. I heard even a higher number at the hearing last year of rate increases, and that's good information for us to have. So if you actually even have any data based on what you've already invested in impact of rates, that would be useful. Thank you, panelists. We do have one member of the public who would like to speak on this particular topic. Let me welcome Julia. I cannot read your last name, ma'am, so I'm gonna ask you.
Cherokee, it's Donahoe.
Donahoe, and I would just say this, if I say your name incorrectly, please say it correctly into the microphone when you arrive. Welcome.
Thank you for trying to get it right. Donahoe is Cherokee, which means there's no A's, U's, E's, G's, or apostrophes. So this is America, and I don't look like it at all, do I? I just wanted to say that I was very, very encouraged by the idea of the wildfire insurance fund. I'm dealing with homeowners on a daily basis. We don't recover from these fires by any of these big policy changes necessarily. We recover one homeowner at a time. We don't get our communities back by any government strategies necessarily unless each homeowner tries to rebuild. And it's only when each lot has someone who cares about rebuilding enough that we get it done. And the financial impacts on everybody is tremendous. And I would like to answer Mr. Khan's question, who pays? The homeowner pays. I see over and over and over on a daily basis, homeowners who don't have enough money to rebuild, they can't afford to rebuild, some of them can't pay off their mortgage, they're upside down, they're bankrupt. The homeowners are bankrupt if we don't solve this problem. So I do want to say I agree with the woman from CSAC that there are unintended consequences from getting rid of inverse condemnation, and I'm very concerned about an idea that you have to do that to solve this problem, and I think there are other ways, and I appreciate that you're looking at all options. And the other thing I need to say is that we really do need to reform the insurance industry. There's some real problems, and I'd like to speak on that later or at another time, but thank you.
Thank you. Anyone else wish to speak to this item? If not, let me call for our next panel. We have a panel on utility insurance. We'll be talking about homeowners insurance in our next session. Let me welcome to the table David Heller, Vice President, Enterprise Risk Management and General Auditor, Edison International. Whoever I say first, just sit at this seat here and then you can all fill in. You are not Dave Heller. Next, Russell Mills, you're up. Director, Treasury and Risk Management and Treasurer, Sacramento Municipal Utility District. Thank you. And then Bob Marshall, like I'm calling a team to the floor field. Bob Marshall, General Manager, Pluma Sierra Rural Electric Cooperative. Welcome. And then Joshua Yang, Managing Director, Marshall McLennan Companies. What a diverse and esteemed panel. We're so glad to have you with us today. These gentlemen are going to give us an overview of what is happening with the utility insurance market. I think we had some questions in our last session regarding whether the availability of it has changed, whether the cost has changed, and how this market compares to other parts of the country. So I think we'll hear from your different perspectives. Mr. Heller, why don't you start us off?
Thank you very much, and good afternoon, Commissioners. I am Dave Heller, and I am Edison International's Vice President of Enterprise Risk Management. Edison is the parent company of Southern California Edison, an investor-owned electric utility serving about 15 million residents through about a 50,000 square mile service area. My responsibility at Edison includes insurance, and I appreciate the opportunity to offer Edison the perspective on the deteriorating state of the insurance market covering wildfire liability in California as it impacts investor-owned utilities, and offer our thoughts on possible risk financing solutions that will help stabilize the insurance markets. Unfortunately, both the insurance and reinsurance markets for wildfire liability are hardening, meaning the number of insurance companies willing to provide this coverage at the same level is going down and pricing is going up. The hardening in the wildfire liability insurance market is also impacting contractors who perform work for utilities in areas that carry potential wildfire risk. These include veg management companies, line contractors, and the like. These contractors are also no longer able to obtain the level of wildfire insurance that they previously had. The hardening of wildfire liability market is due to three key factors in our judgment. First, the increased risk driven by increased residential and commercial development in the high fire areas, the WUI. Secondly, increased densities and property values, drought, lack of fuels management, and quick, dramatic change to the environmental conditions in which we built our infrastructure in the first place. In other words, climate change, which you've heard about already. Secondly, the increased frequency and severity of wildfire events throughout California. And then thirdly, the unique application of inverse condemnation to California IOUs. With respect to the second factor, it really boils down to when it comes to frequency and severity of wildfire events, insurance companies, like all businesses, need to be profitable. And based on the last several years, they indicate they are not. With respect to the third factor, inverse condemnation, insurers face a risk in California that's different than virtually any other state in the country. The inverse condemnation doctrine in California exposes insurers to much greater risks than they face in other states because of what you've talked about already this afternoon, which is utilities are held to a strict liability standard without regard to fault. The insurance market deteriorated after the 2017 fires and only worsened after the 2018 fires, adding substantial costs to Edison and our customers in the form of higher insurance premiums amid a tightening insurance market. To give you a sense of the numbers, in 2017, our total wildfire and non-wildfire liability, so this is both general liability and wildfire liability combined, expense was about $75 million annually. Whereas in 2018, for wildfire liability alone, so excluding general liability now, we paid approximately $235 million, a greater than threefold increase. In sum, many insurers now believe that California presents an uninsurable risk given the state's 4 large wildfires in the last couple of years. Importantly, Edison, as you heard from other companies this afternoon, is taking aggressive action to mitigate increased wildfire risk by, among other things, insulating our electric wires with covered conductor, deploying cameras and weather stations to address situational awareness, and implementing other enhanced measures, including proactively turning off power when the risk of wildfire propagation is the highest. These mitigations should bring some stability or help bring some stability to the insurance market, but alone will not be sufficient to address the ongoing turmoil in the financial markets, given our state is now more or less exposed to a year-round risk of catastrophic wildfires. It is also clear that the commercial insurance markets do not have the overall capacity to insure these catastrophic events. While wildfires can cause damage in the tens of billions of dollars, the commercial insurance and reinsurance markets, by all accounts, only cover up to approximately $1.5 billion. For damage above commercial insurance, there is a critical need for alternative risk financing, an alternative risk financing vehicle, such as a catastrophic wildfire insurance fund, sanctioned by the state, that would achieve broad risk and cost sharing, capitalized with initial and ongoing contributions from all utilities, covered by customer rates, just like insurance premiums. Importantly, associated with the fund, as you talked about earlier, there need to be procedural safeguards to incentivize utilities to take the right preventative measures with respect to wildfire. First, the PUC retains its authority to investigate and penalize utilities for violations of regulations. And second, the fund, which responds to claims like insurance, we see it as an extension of insurance where the insurance market can't respond, will not cover punitive damages, fines, penalties, willful misconduct, and similar, which must be paid for by utility shareholders. Put simply, there has to be a better way for our state to collectively manage increase wildfire risk and take utilities out of the role of serving as the insurer of last resort. This is clearly not our mandate and impedes our ability to serve as leading implementers of state clean energy initiatives and policies. We believe that by hardening the grid and taking other steps to reduce the frequency and severity of wildfire events, along with establishing an appropriate risk financing mechanism, such as a catastrophic wildfire insurance fund, our state will be able to address the challenges caused by the deteriorating commercial insurance market for the benefit of customers and the communities we serve. Thank you very much, and I look forward to questions.
Greetings, commissioners. I am the treasurer for SMUD, Russell Mills, and thank you for allowing me to participate in this forum and give SMUD's perspective on insurance availability and the availability of other financing and financial considerations. As my colleague Joy, who was on the prior panel, has already explained, SMUD is the 6th largest publicly owned electric service provider, serving 1.5 million residents around the state capital region. We operate the Upper American River Project in the higher risk Tier 2 and Tier 3 areas designated in the CPUC's high fire threat district map. With those UR assets in high-risk areas and the existence of strict liability, SMUD carries specific policies for wildfire risk, even though our service territory is in mostly a lower Tier 1 risk area, which is important to know for SMUD. So we do have assets in low populated areas, but do have a densely populated service territory in the lower lying valley region. Last year, we sought out and increased coverage in wildfire insurance markets, roughly twofold in coverage amounts when you take into account the reinsurance that we would have to cover part of the claim ourselves. For that, we incurred a fourfold increase in premium costs. So roughly about 1.5% extra on top of our customers' bills just for insuring wildfire up to a higher amount. For SMUD, there was capacity available, but as he mentioned, it is hardening. We are about to go into negotiating renewals, and we don't know how that's going to turn out. We are anticipating higher coverage or higher policy premiums for the same coverage. So we do recognize that having an alternate way of funding a mechanism that we can access is important to solving this dilemma. The factor for SMUD and all utilities financing plans is the cost of funding, typically driven by finance, how long you finance, and interest rates, but also credit ratings. And I think that's been talked about a bit, and rating agencies have started to comment on the large risk outside of just IOUs, and they include POUs now, and they have asked a lot of questions about our insurance coverages and what we think about coverages going forward. We have responded to many questions from all 3 rating agencies and to investors about our risk profile, and we've also shown the proactive steps that we take, including carrying additional liquidity and increasing the insurance coverage I talked about. And then also we have the operational items that my colleague already described on expanded technology-driven edge management, regular ground and aerial patrols of all facilities, and ignition-resistant construction of power line facilities and the like. As fire events continue to occur, we are all subject to potential ratings migration that will increase our ratepayers' burden from higher costs of borrowing. So finding an alternate way of preparing financially is necessary. We've expanded our commercial paper line to have flexibility and short-term borrowing for access to capital funding if needed, and also the insurance increases. Those measures are great, but I think as we've seen the size and amounts of the 2017 and 2018 fires, could find SMUD and other POUs and IOUs in need of supplemental funding alternatives. We are participating and engaged in finding solutions for utilities to this issue, including the AB 235 proposal. We feel that any proposed solution needs to balance the benefits to ratepayers with the costs prescribed. Considerations for mandatory participation or opting in, opting out are very important. We feel that there can be an equitable way of structuring it such that utilities only pay for the benefits they may receive and thus give the ratepayers cost-effective financial protection. Most POUs will find themselves seeking ways to finance a required contribution, and SMUD has estimated that AB 235 as proposed may raise our rates significantly, as much as 5%, depending on the amount that we do need to pay into the fund to participate. But leave the unknown risk of funding availability if multiple events happen over the course of a couple of years. From a risk management perspective, viewing the fund as a supplement to coverage is going to be necessary for us. In closing, just want to further reiterate that we back a solution that everyone can opt into, or if it's mandatory, make sure that the benefits be matched with the assumed costs and not set up a paradigm of low-risk area ratepayers subsidizing higher-risk areas into perpetuity. All utilities are not the same, yet we all do need a mechanism for funding alternatives. With that, I'll close.
Thank you. I'm Bob Marshall, General Manager of Plymouth Sierra Rural Electric Cooperative. We are a member-owned cooperative utility that serves northeastern Sierra. We serve Plymouth, Lassen, and Sierra counties and a small portion of Washoe County. There are 3 co-ops in California, and we serve a whopping 0.1% of California's load. I have 8,000 meters. 1,050 miles of overhead line, about half of it in U.S. Forest Service or federal lands. We serve 6 customers per mile. For comparison, Turlock Irrigation District has the same amount of line we have. They have 12 times the customers and 12 times the load. We have 30% unemployment up in our district, and 2 of the 3 counties count our hub designation applies there. We serve where no one else wanted to serve. We are basically the leftovers of 3 other utilities had passed on serving power out into rural areas back in 1938 and 39. We took it over. Since then, though, we have rates slightly lower than PG&E. We have better reliability than our neighbor. We've done our work. Once we were an average utility as far as fire prevention. In 1989, the Lehman fire got going. The Forest Service blamed us. Eventually we settled. Our insurance cooperative, which we're part of, came back to us and said, you know, hey, new manager, me, you need to groom those lines. So since 1995, we have spent millions upon millions grooming our line. This last winter was a monster in the Northern Sierra. And there were parts when I was actually working from home because there were trees across my driveway I couldn't get out. I couldn't see the woodshed 50 feet away, it was blowing so hard. But in our entire system, all winter long, 1 sub of 12 had 2 15-minute outages, that's it. We have backup power, we've invested in low carbon cogen power, we built a transmission line to the Nevada grid. We are the smallest generation transmission distribution utility in the lower 48. So we've done our homework. We turn the backup line that runs to the National Forest off in summertime. We put almost our entire western half of our system, the trees, in single shot. We're actually even looking at a program with Generac where for our little bit of tier 3 fire risk areas of buying everyone a Generac and simply turn off that line when it gets it. It's actually, for us, a lot cheaper than trying to go the 10-year process of digging through the National Forest through NEPA and CEQA. When the omnibus bill passed in 2017, federal strict liability was capped. And that was a godsend for us. We thought we got it made now. So the rural electric cooperatives, we serve more than half of the United States. In fact, actually 90% of the land mass of the United States. We own more than half the distribution poles, and we have 10% of load nationwide. The rural electrics formed a giant insurance cooperative called Federated Rural Electric Insurance Exchange. They've always taken good care of us, even though sometimes they needed to, once upon a time, put their foot into our rear to get us to improve our service and our lines. They make sure that all that their covered members are doing everything they should be doing. So we went out for renewal. Last year, we got $35,000 cost for $15 million of umbrella coverage. And this year, no one would touch it, except for Lloyd's of London, who was several $1 million for a massive deductible. Now, that would have been a 10 to 15% rate increase for something that didn't provide very much cover. So we're a little lucky. We have a great track record. Federated comes out and inspects our lines, gives us feedback, and we've done our job. When the CPUC came up to inspect our lines, they came through, and by lunch they were bored. They said, "Hey, can we go look at underground?" Let them look at underground. They just said, "Great job, keep doing what you're doing." The last time they came, they basically found a few missing high voltage line signs on some poles that were built from before that was required. That was it. But no one would insure us. Now, Federated has kept their base coverage for us. I just came from the National Electric meeting in Orlando. And at that meeting, we all sat down together to figure out how to keep Federated's reinsurers from dumping half of our remaining $20 million of coverage. We're going to bring them up and have a multi-day exercise where we show them we are different, we've done our homework, we have lower risk than you'd think just because we're in California. So the thing that struck me though is that Federated is open to rural electrics and one or two other rural utilities like Trinity. That's it. And there's a lot of small utilities that have lines out into the woods, and I don't know if they're going to be able to get coverage. So we've been hearing alternatives like undergrounding. We all did a calculation of those of us in our little trade association called Golden State. The 4 rural utilities who have a lot of undergrounding double the triple rates for every one of us. 10 to 15 years, we're all in national forest, NEPA, CEQA, archaeology. It's just a nightmare. And if you've seen Trinity PUD service territory, ours is a little flatter, not much, but it's how, you're digging in granite. It's virtually impossible. The insulated wires, our view is that insulated wires are being brought to you by the insulated wire companies that want you to buy more insulated wire. The problem isn't that a tree hits the line and bursts into flames. Generally speaking, that can happen. For us, it's that someone has not looked up, thought, oh, look, a nice big dead tall tree. Not looked at the power lines, or they said, I can cut that away from the lines, and then dumped it into the tree, and dumped it into the lines snap, hit the ground, and there the fire goes. We believe strongly is that if we start a fire, we're on the hook for it. We have to have enough insurance to cover it, and our insurance cooperative makes sure that we're an acceptable risk. But we have people who sometimes drop that tree into the line. We have drunks who drive into our poles and dump the line upside down into a field, then marches off into the national forest. We can't control that. We can't control everybody doing something dumb with our system. We can only do the best we can do and hope. With 6 customers per mile, when we look at the pool idea, a voluntary pool is all I would beg you not to make it mandatory. And with all of our line, with the job we do, the effort we put into our lines, any kind of massive statewide pool, the disparity of size of very large utilities, very small utilities, it's very hard to have a fair, equitable balance inside of that on, hey, you did a good job, you didn't do a good job. And really, the bottom line here is that we're trying to self-insure because we can't get commercial insurance because of the strict liability issue. I know someone's got to pay for that, and I think the driving issue at the heart of all this is climate change. But it's not socializing the damage, it's dumping the costs on us. Adding millions of dollars of cost to a small utility is going to put a lot of us out of business. So we hope that we believe the answer is reformation of the law, however the law, I'm no expert on this, but whether it's the Constitution or the Assembly, even a cap would be tremendous. So with that, thank you very much.
Thank you. Welcome, Mr. Yang. You are our insurance representative. Why can't Mr. Marshall get insurance?
4 fires in the last 2 years, costing billions of dollars, that certainly will do. Good afternoon, Commissioners. My name is Jeff Yang, and I'm the Managing Director at Marsh, San Francisco and San Jose office. Today, I'm here really to inform the Commission on the availability and affordability of the liability insurance, which address wildfire liability stemming from property damage, business interruption, and bodily injury for California utilities. Specifically, my remark today are solely intended to inform the Commission understanding of the current state of liability insurance market for this type of risk. Let me start just giving Commission a brief background on myself and my firm. Marsh is the world's largest insurance broker. I have been with Marsh for over 22 years. My current past clients, including Fortune 100 technology and telecom company, large manufacturing chemical firms, and California investor-owned utilities. I help clients define, manage, and transfer their key risks, including general liability and excess liability insurance, covering wildfire liability for California utility. For liability risks that are transferred, Marsh works with its overseas offices to access insurance capacity globally, including carriers throughout the United States, Lloyd's of London, European, and Bermuda insurance marketplace. Next, let me explain just how corporate liability coverage are typically structured. Unlike homeowner insurance, which one carrier, subject to state regulation, offers coverage for each home, most of the corporate liability programs are built with support from many carriers on a vertical tower with similar coverage but varying price. Those carriers are typically non-admitted carriers, which enable them to provide pricing and coverage terms not subject to state regulations. On average, 10 to 50 global insurers are typically involved in a vertical tower. Each insurer will offer between 10 million to 50 million liability limit at different attachment points. Those carriers attaching lower will get higher premium or rate online for capacity they put up due to the higher likelihood they will pay a claim. Those carriers at a higher attachment point will receive less premium than those below due to lower frequency and severity of anticipated claims. Those towers are typically insuring low frequency, high severity liability claims. Per Chubb, which is one of the largest commercial insurers, their Bermuda division usually put out an annual liability limit benchmarking report. The utility sector generally purchased a median liability of $415 million, with a maximum liability limit of $1.25 billion. The larger company, in terms of number of customers, revenue, service territory, and number of other risk factors, the higher the liability limit they typically purchase. The maximum global liability insurance capacity has been consistent at around $1 billion to $1.5 billion. Total liability limit available to each industry sector is usually less than the total market limit due to carriers usually do not deploy their maximum capacity for any one industry sector or any one kind. For California utility, 2 additional forms of property damage only liability insurance capacity are also available. One is reinsurance and the other is cat bonds. And reinsurance are used in 2 different forms. One is reinsurance is used to increase capacity that liability insurer can offer, which is really insurance for insurance companies. Secondly, California utility can access reinsurance directly through a captive to purchase liability coverage related to wildfire property damage. Cat bond, or insurance-linked security, is a relatively new form of capacity available for California utility. It gives them a way to access capital market directly in case of a catastrophe, such as hurricane, earthquake, and now wildfire. Reinsurance and cat bond capacity usually sit on top of the liability program to provide a limit excess of $1 billion. The total capacity for those 2 markets is uncertain at this point, as both markets are experiencing reduced capacity and significant increase in pricing, similar to liability insurance market. The overall liability insurance market has been soft for the past decade, meaning the marketplace has been competitive. Carriers are willing to insure basically all type of risk at a reasonable price. However, a key exception is the California wildfire exposed risk, where insurer has been less and less willing to offer insurance and rate continue to trend upwards. Insurers find California wildfire liability risk especially troubling when it comes to California utility, given the application of inverse condemnation, the expansion of wildland urban interface, climate conditions, the frequency and severity of utility losses, and the deep pocket aura of the public attributes to regulated utility. Today, the liability insurance market covering wildfire liability for California utility is in distress. Both the insurance and reinsurance market for wildfire liability are disappearing, with the remaining market participants increasing pricing dramatically. The California utility sector faced both a capacity reduction, meaning less insurance limit are being offered, and dramatically increasing pricing. The 2017 and 18 wildfire have further accelerated this trend. Currently, the liability insurance capacity is a moving target. Most of the traditional liability insurers has already decided to exclude wildfire liability insurance or discontinue writing liability insurance for California utility going forward. A few remaining large carriers with strong parent balance sheet are still offering large block capacity limit, but premium level that pricing in a 1 in 2 or 1 in 3 loss ratio. Attachment point on a liability tower no longer seem to matter given the severity of those losses, as the excess carrier want to charge the same rate for their capacity, even at a higher attachment point. If wire losses experienced of the last few years continue for the California utility, collapse of those insurance market will follow. We expect the liability insurance market for California utility to continue to be in distress until meaningful legal, regulatory reform, new and improved technology, and mitigation tool can be implemented to reduce wildfire frequency and severity.
Thank you. That's a very substantive panel. I think we'll have a lot of questions. I'll see if anyone else wants to kick us off. Commissioner Common, do you
I
like
defer
to?
to you if you like, but I have a bunch of questions.
All right, we'll start with Commissioner Ward then.
Thanks. Thank you, all of you. That was really informative. I wanted to ask the folks on the buy side of this problem, who are trying to procure insurance, what sort of a deductible do you carry? I mean, we've heard discussion of attachment points and layers in the stack, and it occurs to me that where the level of self-insurance might be important to determining the total cost of the coverage and the amount of coverage that the company can obtain in total. And I'm curious how you think about that, particularly in the context of the disasters that have unfolded across the state over the last several years. Has your thinking changed?
Okay, I'll take the first stab at this. I think last year we increased our coverage from 100 million to 300 million. But that is the total claim, but we have the deductible that takes that down to about 185 million that we're actually covered for. So we're liable out of pocket for the other 115 million. And for that, as I said, we paid fourfold premium increase. And I think what it does is it highlights that having other funding alternatives are necessary when you see the size of the fires and the liability that could occur. So 300 million, take that down, 100 million out of that, it's just dwarfed in comparison to the size of the Camp Fire, for example. So, we look at it as something necessary and having some sort of a coverage, but we also recognize there is need for other funding alternatives. So we've increased commercial paper capacity, and we think that having some opt-in, opt-out insurance wildfire fund is prudent as well.
So before the 2017 fires, we took a $10 million retention, just to answer the question directly that way. I'm not sure what it's going to be today because the markets have changed so much. And as Josh from Marsh indicated, you don't get the typical reduction in premium as you go higher in the tower now. Typically, you would take a self-insured retention to the extent it made economic sense. You take a higher retention if there was a credit given to you for doing so in your premium. That's really not the case now. So we also have two industry mutuals that are excess of 10 million. They don't cover the whole next 100 million layer, but a substantial part of it. They're ostensibly always going to write us, but they're going to want their loss ratios to get in line with what their particular governance is, and so you're going to pay deeply for that. The other thing that we're seeing, which is similar to your question but slightly different, is that we've seen for the first time a co-insurance feature. So the way co-insurance works is if, let's say, we buy 100 million in the first layer, this is just illustrative, ours is higher up, but in the first layer, the co-insurance might say for every dollar of loss that's paid, we pay 25 cents and the carrier pays 75 if the co-insurance is 25%. That's not been the case in the markets prior to this year.
Do you want to?
Just a negligible deductible for us. It's for everyone's worry isn't that first little bit. If it's a fire, it's the deductible isn't the issue. So I mean, it's the top end is the issue. So our insurance cooperative has not encouraged or pushed us towards any kind of high deductible.
Okay, next question. Let's assume that there's some sort of an insurance catastrophe fund similar maybe perhaps to a Assemblymember Mays's proposal, something different than that, who knows, right? Something that we're thinking about and we'll be working on perhaps. Do you have thoughts about where the attachment point for that should be? Because that's a really important issue, right? And presumably, and I'm interested to hear your perspective as well, a higher attachment point for this kind of a fund, it would be above whatever commercial insurance you're procuring, would perhaps open up the availability of more affordable coverage, right? If we're talking about really only insuring, you know, the kind of catastrophic events, is it your thinking that might enable the state to procure coverage? Because if the market's in crisis, the state of California is going to have a hard time going out perhaps and buying coverage as well. So I'm curious what your thoughts are on that, and if you have any perspective, market perspective.
A quick comment is that the.
I don't think your mic is on.
No.
Oh, is it? Sorry.
Try again.
There we go.
He did it.
Try again.
Get your replacement in that one.
Yeah. So there's kind of a problem with the size issue. You've got the smaller members of SCAPA, some that, you know, Bear Lake. You've got a lot of different size utilities. So a lot of the small utilities having a common pool, somewhat common sizing may work. But even an NC, Northern California Power Agency, which we're part of, you've got, you know, Ukiah, Gridley, and us. Gridley's smaller than us. Ukiah is about our size. Healdsburg is. It's huge swings on exposure and huge swings on load. And what makes sense for a big uni or, you know, one of the biggest IOUs, the size issue would kind of complicate that for us on God is in the details. That's my answer. God is in the details.
And I'll echo that point of view that we think that, you know, size does matter in this equation as a larger MOU, POU. But, you know, we think having an attachment point that is relative to what our coverage is will help us in determining, you know, how much participation, assuming that it isn't opt-in, opt-out, and you do have some scalability to it. If it's mandatory and there is an attachment point prescribed based on our size, I think we still see the benefit of having alternative funding mechanism, but we would have to look at how it's actually structured.
We've given this a lot of thought, as you might imagine, and we do see it as a catastrophic wildfire fund. It would clearly have to scale. There are probably as many solutions to scaling it for the size of the entity involved as you can imagine, including putting smaller entities, I don't want to be presumptuous, their call of course, but into a cell of their own so that they get size and breadth. We also see it as a property damage only fund. And this is, I think, important relative to your question about where the insurance markets recover. If you complete the inverse condemnation doctrine by allowing cost recovery through a fund, remember that inverse only causes or is allowed for property damage and attorney's fees. So if the fund covered property damage and attorney's fees, and all of the other potential tortious conduct is left to the traditional commercial insurance markets, in theory, we think that those would recover over time because they now can underwrite the leftover, if you will, you know, bodily injury, business interruption, and other tortious cause of action, as they do in any other industry. And the inverse part, that is property damage, is left to the fund.
And actually, Mr. You were nodding your head with that. And so I wondered if you could respond. And my general question for you related to this is, you listed lots of reasons why the insurance industry is concerned. But if our utilities do everything possible, world first-in-class wildfire prevention, technology, et cetera, but there's still wildfires,
Yep.
Is there going to be an insurance market?
Not when it happens every year, right? Because they're in a business to make a profit, and no amount of premium is large enough if they're writing a check every year. And I think some of the examples given earlier by Commissioner, you know, for example, spaceship hitting the line, or, you know, anything else related to that, or some of my panelists talking about what you think about the basic liability doctrine is that you did something wrong, right? And when you didn't do something wrong, and for things that's outside your control, especially if utility did everything prudent to protect their, hardening their systems, and then wildfire still happens, yet how can insurers assess how much to charge a utility company from that perspective? And then on the limit question is, I think I stated that in general where the insurance market is, and each industry that's been very, very typical. So the size of the losses is unprecedented, so I just do not think there's enough insurance capacity in the world anywhere to buy up to the limit that could potentially cover some of the recent losses that we had, which given, estimates are north of 10 billion easily from that perspective.
So can I?
Yes, please.
I want to focus on a couple of parameters that you're articulating. You said that the market only bears $1.5 billion, $1.5 billion. So as I understand what you're saying, you can't buy insurance for a $5 billion or a $10 billion liability, even if you wanted to. Is that what you're saying?
That is exactly what I'm saying, and I think others agree. And I want to also point out, this was true even before the 2017 fires.
No, I understand, but I just want to, we need to have some basic facts that we can work with. So fact number one is, it's not possible to buy insurance for the scale of the problems in Tubbs and Camp and the like under current law. Is that right?
That is absolutely correct.
Regardless, okay, so that's number one. And in fact, the limit is all we can buy, no matter how much we pay, is 1.5 billion. That's right?
Approximately. There might be some cat bonds above that, but cat bond capacity is not substantially going to add to that.
Okay. Fact number two is under current law, your exposure with strict liability, and it seems like you don't like this very much, but under current law, your liability or PG&Es or whatever is unlimited. So presumably after the insurance goes, you exhaust all of your stockholders' money, and then that's the end of it, right?
No, actually, the way it would work is after we burn through our insurance, we would submit to the commission for cost recovery and go through a prudency review. If we're prudent, then under the current law, under Section 451 of the Utilities Act, we would get cost recovery for those expenses related to the wildfire that were deemed to be prudent.
The ratepayers would pay.
The ratepayers would pay for it.
The ratepayers would have unlimited liability.
That's correct. If
Okay.
we're imprudent under current law, and that's the whole rub with the 2007 SDG&E fire,
Right.
then it goes to shareholders.
And in that case, if it's unlimited, then you run out of money, it's over. Okay, so it doesn't sound like insurance is the solution to this problem.
Commercial insurance is not the
Okay.
solution to this problem.
That's the first thing. That's the first thing I wanted to establish. The second thing I want to get to is nobody has commented on the economic effect of eliminating inverse condemnations. I take it you agree with SDG&E's notion that there should be some certainty and some prudency standard in which there's a limit to liability of the utility. You agree with that, right?
Absolutely. There has to be a clear definition of prudency.
I would hazard a wild guess that PG&E also agrees with you about that.
I think that's a good guess.
If that were the case, I'd like to ask Mr. Jang, what would the effect, if the utilities goal were achieved, what would the effect be on insurance? Would they be able to get at least the $1.5 billion at a reasonable cost if the IC law was changed?
It's a little hard to say right now, because when I look at the last few years, every time a big fire happens, you have to wait a year and a half to figure out, waiting for the CAL FIRE reports to come out to determine liability. Even that, you may still have an argument of who's responsible, if inverse supply or something else does. The question for a lot of insurers right now on their mind is, when you have two big fires on both north and south in 2 years in a row, that kind of frequency and severity is not acceptable. Whether it's inverse or not, I think insurer would view that similar to some of the other liability risks that has happened in the past to be uninsurable.
So we may be facing a problem in which we not only have a problem above the 1.5 billion, but we have a problem up to the 1.5 billion because obviously, I'm sure the insurance carriers will sell us $1.5 billion of insurance for $1.5 billion of premium. Is that right?
For probably 1.6.
Okay.
Yeah, I'm probably being lowballing.
All right, so we're not solving the first 1.5, or maybe we are, but you're not giving me any comfort here. Can you find somebody in the end? So then I want to turn to this business of everybody's been talking about this magic fund, this catastrophic insurance fund. I want to know whether you're advocating, and I know there's disagreement about how it's going to be funded, and the people who are in the low risk areas don't want to pay the premium equal to the people in the higher risk areas, et cetera. I get all that. But what I don't understand, nobody's talked about a cap. And so my question is, in a catastrophic fund, and I assume that you're looking to the governor and the legislature to do something here, has anybody shaped this in terms of what a cap should be on the catastrophic fund? And if so, I'd like to get some advice about that.
I'm happy to address that. Yes, is the answer. We've done modeling, and I obviously don't have that with me today, but we're happy to share some of that modeling with the commission. And when I say we've used outside modelers. There are about 3 in the world that do this for insurance purposes. We've used AIR or AIR. And that in turn has informed some assumptions that we've made when we looked at the viability of this fund. And one of those assumptions has to be what's the stop loss for the fund.
Right.
And the way we've run it is a $20 billion per occurrence and a $30 billion in the aggregate. So I want to emphasize that these are assumptions. You can pick, if you want to pick 15 or 30 or 50, you just run the model and see, what the cash flows are that come out of it. So one of those assumptions, though, has to be a stop loss. It can't be infinite.
So there are, I just want to be sure we understand. We have 3 parameters, as best I'm able to understand it. 1 is the cap. 2 is what we're insured for. So presumably, if the entire concept of inverse went away, but we still have the uncertainty that you're talking about, presumably over time, the cost of this for the 20 or $30 billion cap will go down. So element number 1 is the cap. Element number 2 is what we're insuring for, right? So in worrying about this fund, we need advice on what we're insuring for and a cap, right?
Yeah, and again, we'll provide you some information that not only shows our assumptions, but you can play with the assumptions. But you're right, a cap in the fund, we need to know what's insured, and we're advocating for property damage only, because that solves the inverse condemnation problem. That's where the issue is. And then the third would be the retention, which would have to scale for the size of the company.
Right, and there seems to be at least a disagreement here about, to use Mr. Wara's construct, where it attaches. We're not sure whether it attaches, we may have to attach $1 at the current market or, later. So we don't know that yet.
We don't, but maybe what we can say is what we do agree on, and that is, I think there's generally agreement amongst industry. I'm not talking about the commission, obviously, or others, that it should be a catastrophic fund. And then secondly, the catastrophic is different for us than it may be for SMUD, than it may be for a co-op. So there are some general parameters that we agree on, and use that as a construct to work out how the structure of the fund would work.
Okay, well, this is the final observation to you and anybody else who's listening to this. It would be a lot more helpful to me anyway, and maybe my colleagues, if someone who's proposing this catastrophic fund, and everybody seems to like the idea, but those three parameters we need to understand. Anybody who's advocating a catastrophic fund needs to be telling us what's covered, what the cap is, and how that is going to interact with the current ability to buy insurance. And there's of course a fourth issue, which is so hard. I'm going to leave this to Carla, and that is how it's paid. I mean, there's a food fight over how it's going to be paid for, whether it's ratepayers or taxpayers or the like. But I understand that you all have different views about that, and we probably don't need your advice on that, because one thing for sure, where you sit is probably where you stand on those issues.
Yeah, I will say though, if this is okay, Commissioner, that regardless of what the funding source is, it needs to be broadly socialized for this to pencil out. So whether it's all ratepayers or all taxpayers, or that's key to making this work. It is actually socializing the cost.
Right.
Which isn't voluntary anymore.
Well, no, I don't know. It may be that it could be opt-in, but you have to certainly, Commissioner Peterman, you have to have critical mass or it won't pencil out. But once you have critical mass, I'm not sure it has to be mandatory necessarily, especially for smaller entities.
Well, this goes to the whole question of equity, and I would just make the observation to our staff, thank you very much for inviting the gentleman from Plumas, because it puts in sharp relief the differentiation of how this falls, and the equity issue is really, really difficult issue, but I personally appreciate the mix of perspectives here. Thank you.
That's great, please.
Yeah, my question is, as we go, we have this conversation about what's available, who can get it, what it's going to cost, then, do we as a commission, do we think we ought to be also talking about the structure, the entity that is going to administer such a fund, or are we going to leave that to somebody else? Because I understand that they've had the legislative hearings and they drafted, and Mays has this bill, but I'm just wondering whether or not it would be part of our responsibility to look at what's being proposed and come up with our suggestions as to how the fund should be structured, paid for, and administered. Because I look at the language in May's bill, and it's essentially appointed by the governor and the legislature, and they get paid for travel. Okay, so I don't know how anybody else feels, but if you're giving this level of responsibility to this body, shouldn't it have greater weight than volunteer appointees who get 54 cents a mile? Because this is really a significant issue for the people of California. Because in part what we're talking about in dealing with the wildfires and the utilities and the ratepayers, it's all Californians. So I understand that as you come up with the plan to contribute into this fund, you've got to take into account who's the participants. But it also strikes me as though this is something that ought to be spread across all taxpayers. That's just my initial reaction to what we're talking about. One, because you bring the cost down. And you're going to have people who complain about it because they don't want to have to pay another 50 cents. I mean, I lived in Fresno for a while, and I still remember that there was a proposal to add 25 cents to people's water bills, and they went nuts. Just couldn't stand it, a quarter. But the fact of the matter is that this is a California problem. It isn't a utility problem or a ratepayer problem. It's the state's problem. And as a member of the state of California, I want the people in Northern California and people who live in areas that have higher fire risk to have, I just think other people, the entire people should share in that responsibility. Because as Californians, we should all share in the benefits, but we also have to understand that there's a part of that we have to share in some of the liabilities as well. So it's an open question to my fellow commissioners as to whether or not, as we talk about, I mean, it's easy to do the 30,000 foot thing, and have conversations about, gee, we should have a wildfire catastrophe fund. But the devil is going to be in the details, as we've been talking about today with Plumas and you folks. So I don't know, I think that maybe we're in a pretty good position to take a fairly deep dive into how you structure. Let's assume we all agree that the catastrophic wildfire fund is a good idea. And since now we've been told, no matter how much money you have, you're not going to be able to buy more than 1.5, maybe 1.6 billion in insurance coverage, there's a tremendous gap that we've got to bridge in order to resolve this issue of reliability, stability, and the future of how we handle energy and these issues in California. So I'm just raising that.
Well, Commissioner, I think you've set up well our next two meetings where we can do a deeper dive on some of these points. But I think our responsibility is to provide recommendations for something that's sustainable. So to the extent that the entity, the structure matters in terms of that, I think it's reasonable to opine. I've had questions about bonding authority, et cetera, and are there existing entities that could take on this role versus creating something new? And with your leadership on the Little Hoover Commission, I think you understand very well some of the organizational tools that we have. So I think that's worth considering. And I think we have the opportunity to both provide input at a 30,000 foot level as well as in the weeds. I don't think it's not our responsibility to put together a full legislative package, and so I think whatever we can do to inform the legislature this year is helpful. I will caution us though against chasing a moving target. I would rather not opine explicitly on the Mays bill, but more have us continue to think about what are some of the elements that make something workable, so that at the end of the day, in the 11th hour in legislative session, the legislature has something to go back to that we've created that puts some of these markers in the sand. Other thoughts on that?
Well, first of all, Commissioner, thank you for raising that. And here's how I look at it. I think we have an absolute obligation to identify what is not working. We have, and what I'm hearing from this, and stand up and tell me I'm not hearing right, is insurance currently is not working. It's not available to solve the problem. So if that is the fact, and that's what we include, we need to tell the legislature and the governor what's not working. Whether inverse is working or not seems to be a debatable issue, but we need to wrap our minds around it. We need to figure out what's not working in an objective fashion so that the legislature and the governor can know what they have to address. That's my view. As to what to do to fix, I think that we need to be as helpful as we can with parameters of what the elements of the fix are. So Commissioner Nava has suggested a fairness principle and a risk rating principle. I think we need to think about that. As to the ultimate fix, and frankly the mechanism for fix, that I think is a bridge too far. We can't figure out the insurance market. On the other hand, it does seem to me that we can, if we agree that we need one and there are parameters and here are the issues we have to face, we can be pretty unequivocal about that. And also say this is not, this isn't for the faint-hearted or for the volunteer. The state has had things like redistricting commissions and other commissions where the obligation of commissioners or others to fix something were. So I would suggest that we need to say what's broken and has to be fixed. We should articulate things that we think are important that we've learned about equity and the like in terms of giving guidance. If we're smart enough to figure something out, great, but if we're not, we need to tee it up pretty unequivocally. That's what the legislature needs for us. And just a final observation in that regard. I personally understand that there was discussions before about this. I don't think anybody concluded, I disagree that anybody concluded, well, it's not useful to talk about inverse or it's not useful to talk about anything. The state has got an unprecedented problem and we need to face it de novo. That's what the commission's for.
Yeah, a brief comment, and we're going to ask final questions of the panel. I have one more question for our short representative. Okay, go ahead. Why don't you ask your final panel question and I'll conclude with mine.
So I heard a number of people say, but I say this, but I want to just confirm what I heard from you, Mr. Jen. that without a change in the physical risk environment, right? Without better outcomes in the world, this is uninsurable. And so this isn't our charge, right? We're supposed to be thinking about how to socialize costs. But one thing I thought I heard was that there may be no way to socialize or spread these risks through an insurance mechanism, private insurance mechanism, unless industry practices change in such a way that there are fewer utility cost emissions. Is that correct?
For California utilities specifically?
Yes.
Yes, I think if the frequency and severity stay the way it is, I don't think the liability insurance market for this coverage will exist. Just because, again, when you have one occurrence every year, that's going to burn through the entire tower, that every insurance company can pay the entire claim. That's just not sustainable.
And that's very related to what, go ahead.
One comment though is that if you look at, sometimes I think in California, we can sort of forget there are other states. And we have New Mexico, Colorado, Wyoming, Montana, all have climate change hitting them, and they're all having huge issues going on. And my brethren out there are able to get cost-effective insurance. The only difference is strict liability. And, you know, everyone's getting hit by it. So when we look at how do we fix this, it's, we have neighbors who have coasts and we have all different types of vegetation, and they are able to afford insurance. And yes, they're seeing catastrophic wildfires, and yes, the premiums are going up, but they're getting coverage. And that's the huge difference between me and between my fellow cooperators.
And then just, I'm going to use chair prerogative and wrap up with a final question to you on this point. But we have other time to discuss, which is, given this comment that you just heard, what is the different situation in New Mexico? And my general question I was going to ask you was this: there are other states with catastrophic funds. I think what we're hearing a distinction here, though, is that in those states, there is some commercial insurance available. I wonder if you could speak to, are there other states that have catastrophic funds with no access to commercial insurance?
Commissioner Peterman, that part of it I'm not as familiar, but what I just want to address the first question related to availability of the other and how insurer looking at why California is so different. If anybody compare our home prices to Colorado, New Mexico, and anybody compare our population density to any of those states, I can guarantee you the same fire over there, even with the same acreage versus what happened in California, the damages are going to be dramatically different, right? And that's what I talked about earlier about attachment point, where people play on a tower and where the loss is happening, right? Show me another state with similar large fires that's caused $15 billion losses.
Mr. Khan, go ahead. If you
The only thing I was going to say to staff, and this was perfect, what he said, with all due respect, is nothing we can rely on. If we are going to make observations about other states, we need to get data that's reliable. And the observation by the gentleman from Marsh proved my instincts on that point. We cannot go to the legislature and say anything about what other people are doing without reliable data. And that's really, really important.
Well, thank you all for a very interesting panel. I think we can continue to talk to you the rest of the day. We will not, but we would welcome your written comments at some point, and hopefully you'll be available for us to follow up as we finalize our recommendations. Thank you.
Thank you.
We're now turning to our last panel, and as they come up, I'll ask everyone to stand and stretch your legs a little bit. Appreciate the attention you provided. We'll be joined now by three community local government representatives for our community needs around wildfire damage. Okay. And when we come back, we'll have a public comment first.
That's great. Thank you very much.
Thank you, Chairman Peterman. I was in front of you at the CEC when I presented a fuel cell that we built in Santa Rosa.
Wow.
Yeah.
Hopefully that was nice.
You were, and I thought you were amazing. I thought, I want to see her again sometime, so I had no idea today was the day.
It'd be nice if it was under slightly better circumstances, but good to see you on the list.
Well, this is a learning curve for all of us, and I'm having a lot of fun learning, so that's always good for me. I wanted to bring up the topic of mass tort. I know the Attorney General's deputy was here that's specializing in tort recovery, and that was kind of a piece that was missing from this last panel, is understanding the homeowner's point of view and the homeowner's insurance point of view, because we were talking about the utility company insurance. And I think it all comes down to what's happening in the mass tort. So I've been working with some of the guys in Santa Rosa who are doing mass torts, and I've had some clients who wanted to do the mass tort. Should I do the mass tort? Should I not do the mass tort? And partway along the way, at first it seemed like a great idea, but it's like a 5-year process for people to go through, and that those suits have nuisance, trespass, public utility commission, inverse condemnation, and negligence, and health and safety code violations. It's about 7 causes of action. So they're trying to hit it on all bases that they can. But what happens is that if you go back to the Cedar fire, the homeowners sued in mass tort, and the insurance companies came back afterwards and subrogated. And they said, you've got to pay us something. And then there was a negotiation. And so when you get your first payment in insurance, it's called ACV. The second one is the replacement cost if you actually rebuild, but it's usually not enough to get your house and your blue jeans back. So then you're suing, and you get also emotional damages in the mass tort. So if you go for all of that, and then the insurance comes back and says, oh no, we need our piece back, then that's where the subrogation comes in. But what's happening in Santa Rosa now is that the insurance companies didn't in Cedar Fire, they negotiated for half of that. You know, they didn't really get their whole amount back. They just negotiated an amount, and they all moved on. And so this time, the insurance companies are saying, no, we'll just go sue PG&E ourselves. So if this were a flick of a cigarette, as opposed to the utility companies, the insurance companies wouldn't have that option. So the inverse condemnation is really creating an option for State Farm, Allstate, AAA farmers to recover everything that they pay out, which is not what we should be doing. If you want to socialize risk, take away that option from them. Make the catastrophic coverage not have that subrogation option. That is where you could really make a change. And the homeowners, some of them lost family members. They had no warning overnight. They went to sleep at 10, they woke up at 1, and they were either about to die or they lost everything in very short order. By morning, the town was devastated. And the stories go on, PTSD, physical injuries, all sorts of losses. Those do deserve an opportunity to recover if PG&E is at fault. But maybe the insurance companies shouldn't be able to go subrogate first. It really takes away the possibility for the homeowner to even want to do it. It's a 5-year process, it's very difficult. And then the attorneys don't really want to take their claims as much because theirs are much smaller now, and the big suits are the insurance companies. So I've had trouble whether to recommend anyone to go through with it because it's a lot of work, and the recovery the homeowners are going to get is much smaller now, and it changes the equation. But it's really these big insurers are going to get all their money back if they're successful, and they're going to build a new skyscraper in Chicago or somewhere else. That money's not staying here. Our ratepayers then are paying for State Farm to have a new skyscraper. So that's one area where I think that you could have some success and should dive into.
We will be taking on the issue of residential insurance in the next meeting, so we welcome you. I think it'll be closer to your home, actually.
Yeah, well, I'd love to help you figure out who to invite. So I know it's a delicate issue, and Dave Jones is in the room for that I was able to say all that. So thank you.
Thank you very much. I think it's a good transition to our final panel. Mr. Tippin, Ms. McCracken, and Mr. Minturn, welcome. We've assembled this panel because we want to, in each location that we go to around the state, hear from representatives from the local community who have had to deal with costs and liabilities related to wildfire. We've heard a little bit from the representative from the Association of Counties about some of the initial costs that you face. And so this is just your opportunity to share with us some of your insights. Welcome. Please begin.
Thank you, Barry Tippin, City Manager of the City of Reading. I welcome you to our fine city, and I also thank you for coming up and taking on this very important issue as a state. We're facing some unprecedented conditions, and I think it's good that we are taking a holistic view to address these issues in hopefully a better fashion going forward. I think we all recognize that in these events, there's an extreme amount of community impact that ranges from financial to the emotional. And I think while I won't delve much into the emotional impact, I think it's important that we don't dismiss that, because while, as a functioning government, we have to forge ahead and make sure that we're rebuilding and recapturing a society that was once just accepted as the norm by the community. We also have people who are struggling in many different ways, and there's great facets of difference between individuals, some who just roll with it and are able to rebuild. Maybe it's because they have better insurance or just because they're better equipped, all the way down to the other person who is fully insured but is still struggling just with the loss and the PTSD, as we just heard. And so I won't focus on those elements of that, but I don't want to lose sight that as I make my comments, that's not really at the forefront of any executive's mind when you're talking about rebuilding a community. I'm going to focus on a couple things. One is these, and actually this was some ideas that were presented by your staff that might be of interest to you. One is the different financial resources that could be available as we move through a recovery such as this, and then also what are our unmet needs as we move through that. And so, I think it's important to note that our state is really pretty amazing in its response to emergencies. And I think we need not, we shouldn't forget that. When that emergency hits, the ability for our state to mobilize mutual aid to actually come in and get after the threat is just really fascinating and amazing, and I think it's unparalleled throughout this nation, at least, perhaps throughout the world. And so during that initial emergency, especially as it moved into populated areas, the response from CAL FIRE, from OES, and from all the other agencies was just phenomenal, and the resources that come to bear are just wide-ranging and almost unending to deal with that emergency. And we had elements from the, as I said, CAL FIRE and other state agencies to other fire departments who had technology that could be used and helped in the recovery efforts and also in identifying hotspots. Where we couldn't get those permissions by CAL FIRE, they knew how to get the back channels and got it approved within an hour. And so those things, I think, should be mentioned and should be noted. But as you move into post-emergency threat, the fire is moving on, and you start to look around and say, okay, what's next? That's when it becomes difficult. In the immediate aftermath, the promises, quite frankly, are vast. We can do this, we can do that. The reality is that the details really prevent actual receipt of those funds, and or the promises were made aren't quite correct. And what I mean by that is, if you look at the damages that are caused by the fire that are not directly related to the fire, over a period of 3 or 4 weeks, you start to realize as a government entity, there is no funding source. Erosion control. I mean, interestingly enough, we had Cal OES and others telling us, don't forget about your erosion control, because now you're going to be heading into the rainy season. And we reminded them that here we have big rains in October. And they said, yeah, we had lots of erosion in the Santa Rosa. Of course, that was later in the season. And we said, great, how do we address that? They said, we don't have any money. There is no funding sources. Perhaps if you had 40 acres and you were in the county, there's other sources that can be acquired, but in residential areas or in urbanized areas, no funding. You have to go figure it out. Thankfully, in some of our areas, we had the water board stepped up and actually gave a grant to the Western Resource Conservation District, and they actually did some. We also had local nonprofits who stepped up and actually provided erosion control in and around private properties. And so we had Rotary clubs and others. So we had some community engagement to deal with some of those issues, but we were unable to actually find any sort of source that would deal with the post-fire damage. And so erosion control, we have storm drain issues and protection to prevent future flooding, because everybody knows when you have those debris flows, they clog storm drains, that creates flooding. No funding sources for dealing with that. So we're doing that all with our own resources. It's all unexpected. And the commission may not know this, but within a storm drain utility, there's no rates. Or if you established them back in 1991 like we did and they don't have an escalator, you can't change them because of Proposition 218. And so we have 4 people for 62 square miles running our storm drain utility. 4 people. And so, we're trying to deal with that. And then you think about surface water and the pollution that comes from hillsides into your surface water systems. And so we're trying to find sources that we can protect our water system, our water purveyance. So those are issues that I think people forget about, post immediate threat. And then you find these other programs and you say that seem very viable. So there's a 404 program that you can apply for, and they give you a notice of intent in October. We had our fire in July and in August, and so we rapidly put in for grants. I can tell you that we put in our grants for reforestation and wildfire mitigation, but we also did for erosion control along our river and our susceptible areas. We got a notice of intent that, yeah, that's great. We're still waiting to find out if we have any grants. At this point, I suspect we're going to get a grant after the rainy season's over for erosion control. I'm not sure we'll need it at that point in time. So, re-looking at some of these programs in terms of their timing, I think is critical. And also re-looking at the ability to, and this, one of these issues is not the state of California's, but NEPA, right? When you have to go get NEPA clearance, we have emergency restoration approval through FEMA for our river trail bridges. We have 4 bridges that actually have not been able to rebuild, and that's an emergency access route, plus it's a route for the Bureau at Keswick Reservoir. Well, we're still waiting for them to actually clear it so we can actually fix those bridges. We have a contractor, we're ready to go. It's been 4 months. We're not in the water, we're not doing anything, we can't get clearance. And again, that's not your deal, other than the fact that unlike Caltrans, Cal OES doesn't have any delegation of authority to actually do NEPA on behalf of the federal government. I think that would be a good thing. When you look at the process and the financial needs and the unmet needs, I think that really is dependent on the scope and scale of the disaster, as well as your economic base. And if you look in Reading, the difference between what the county may face from an economic perspective, what the city may face, are different, largely because of 2 factors. Number one, there was more homes destroyed in the county than there were in the city. And the other factor is that when people begin to rebuild, or they're buying products for their property, or they're staying in hotels, they're staying in the city. So we're seeing some increases in sales tax and TOT tax and other things that the county doesn't get to realize. And so that component makes a huge difference in terms of what your unmet needs are and how you deal with that, because there's a significant amount of upfront cash that is required for restoration. Even if you have the national declaration, which will provide 94% reimbursement between state and federal governments, most of that's that you're not going to see for a year or more. And so you have to find ways to actually fund those activities and all that restoration prior to seeing a dime. We're pretty fortunate that we've seen $100,000 reimbursement from FEMA at this point in time. And so we only have about 12 million plus to go. We're hopeful, and Cal OES actually is working well with us, and they provide a lot of good recommendations and mentorship, but it's a long and arduous process. And lastly, what I'll touch on is something I think that would be nice to get a little more formalized, and that's the debris removal. I can't say enough about Cal Recycle and how they went about their business and how they did their job. They were very, very helpful for us. They gave us good guidance. I think I would commend both Mr. Minturn and my Director of Recovery, Brian Crane, for their proactive work, working with the Cal Recycle and Cal OES to make sure that we had all that process underway and accomplished it in quick order. However, theoretically, you're sitting there with a 6.25% share of that debris removal. I think Pat, ours is over 100 million. And so, you're looking at a $6.5 million plus or minus share that we're gonna have. The state tells us, don't worry about it, it's not gonna get built. And history will tell you that's probably true. But try to find that in a budget document or in a statute or anything other than an email that's floating around from staff. You can't. And so it makes us relatively nervous to say that we don't have that sort of a financial debt that's going to be called soon. Now, I don't think it's going to, based on past history in some other locales, but it's the type of thing that if we're going to solidify our response to these emergencies and dealing with everything from the emotional to the causation to insurance issues, we should also be looking at the complete package of financial stability within the government system. And those are the types of things that I think would be important. And with that, I'll close my comments.
Thank you. Let me just ask you a quick clarifying question, just get a sense of the magnitude of the cost. So you mentioned expectations from FEMA for 12 million. Out of what in terms of your total cost? So that deal with the lion's share? Does that deal with the property?
That's the lion's share. We were very fortunate within the city in that we had the fire came up and into our subdivisions from the exterior, of course, but it didn't jump. Unlike Santa Rosa, we did not have a lot of significant jump into the city and through the city. It jumped into neighborhoods and then leapfrogged over a couple of streets and so forth. Our major damage, and I hesitate to say this, was our electric utility. And we lost probably $8 to $9 million worth of electrical infrastructure. And so that's the lion's share of our costs. The rest is overtime, bridges on our river trail, and various other aspects of the actual fighting of the fire itself, apparatus costs, overtime and all that.
Thank you. Good evening. My name is Sherry McCracken. I'm the CAO for Butte County, and thank you for inviting me here today to testify. I'm also here to discuss local impacts, obviously, from the Camp Fire to our communities and to talk about gaps in the emergency response and recovery efforts that we've experienced as we work with our federal and state partners. So this truly is the human side of the story you're hearing today. Obviously, we are still knee-deep in fire response. We aren't even in recovery yet. Campfires had similar impacts to those that were just discussed by Mr. Tippin. There's two exceptions that we're seeing. One is, though it's hard to quantify, there is a greater feeling of uncertainty and less hope for rebuilding in the Camp Fire than we've seen in other fires, and God knows Butte County's had its share. It's the order of magnitude of destruction that is, I think people just can't quite grasp. And second, the order of magnitude is also testing every level of government. We all, from the federal, state, local, it's teaching us where our limitations are, and it's showing us there's a lot of work to do before there's another big disaster in California, especially in rural areas. You've heard the staggering statistics, 19,000 structures, 14,000 households have been displaced. So 30-something thousand people suddenly don't have anywhere to live. 85 people lost their lives. And as we were hearing the insurance cap of $1.2 billion, the state Cal Recycle debris removal program alone, the estimate's about $1.8 billion just for partial debris removal. Know that my statements today are not a reflection of individuals. I truly value and have worked with our state and federal partners through many disasters. And I appreciate that I and my staff have a lot to learn. This is a big disaster for a small government to manage. So the impacts are varied, and we don't know how this is going to reshape Butte County. This is so big, the county will not be what it was. Housing impacts are the most pressing. We had a 1 to 2% vacancy rate throughout the county. We now have 30,000 people with nowhere to live. And so, and the areas that burned were where a lot of our affordable housing was. It is taxing FEMA, it is taxing the state to try to find places for these people to live. And we're actually losing people to other areas daily due to lack of housing. So I think this will be the first time we will actually, in a census, have a lower population countywide than we have in the past. The economic impacts are still to be determined. We lost 1,400 businesses. It's huge in a rural county. The related jobs that were tied to those businesses. It's going to hit the region's economy, not just our local one. And the loss of population will affect businesses in the region also. No housing, people leave, businesses start to not be able to sustain. The damage to the public and private infrastructure is staggering. Utilities still only have temporary fixes in. PG&E has put up temporary lines. There's not final utilities in yet. The town's sole source of clean drinking water that serves 10,000 households has to be completely replaced. They're predicting 2 to 3 years before there is clean drinking water in the town of Paradise, absent a temporary solution. None of our roads, including our state highways, were built to handle the level of traffic from heavy trucks, from fire equipment that we've experienced, and that will extend up in here to Shasta County, Tehama County, Yuba County, Sutter County, as debris trucks, thousands of them for the next year, are going to be going up and down the corridors to landfills. The life of our landfills are going to be shortened, and it's not cheap and easy to put new landfills in the state of California. And we have over 100 private bridges and numerous private roads that have been destroyed, which are obviously a challenge for debris removal and rebuilding. My guess is a lot of those aren't insured. And we have yet to discover the extent of damage to private wells and septic tanks. The watershed impacts are huge. We sit at the top of a lot of major watersheds in the state of California, and we're finding that jurisdictional responsibilities are not clear. There's a lot of, is it the state, is it the county, who's in charge of drinking water? And so testing and monitoring, the state has stepped up, but they don't have the funding to do this, so they're scrapping for money to do that. Hazard trees, whether a threat to public, on the public right-of-way or a threat to the public right-of-way, we're looking in the county jurisdiction, which is about 1/3 of this fire, of about 110,000 trees that need to come down. That's $110 million if we get a deal for order of, economies of scale for cutting trees. There's nowhere for that timber to go in the state of California. So what we have are log decks building up so they can burst into flames this summer. So it's a vicious cycle with the trees. Public health and safety impacts are long-term, obviously. Debris cleanup could take up to 18 months. Meanwhile, the toxins and everything are sitting there. And who knows what the long-term health issues are. The smoke, I think the whole state got to breathe in the smoke. Obviously, trauma, we have people with primary trauma, the fire survivors and first responders, secondary trauma suffered by all those supporting the incident. We have increases in domestic violence, drug overdoses, crime is going up, symptoms of massive trauma in our area. And mental health services are already in short supply for the size of our population, demand's increasing. Medical services were hard to come by in the North State, even more difficult. One of our hospitals is gone and all the medical personnel that were tied to that. And then there's the supporting jurisdictions which are suffering collateral damage. They had to bring in these 30,000 people without homes and 50,000 that were ultimately evacuated. Their populations, can you imagine if Reading's population grew 20% in one day? So demand for services skyrocketing, revenues not. There's no additional housing stock. We have people crammed in single family homes, apartments, living on the street, living in RVs, dry camping. All of this, and FEMA and Cal OES are not tasked or resourced to help supporting jurisdictions. They just help within the disaster footprint. And so this is something we haven't seen in the past. Normally our surrounding jurisdictions can handle it. It's not that big of an impact. And then there's all the unknown impacts. Who knows what the long-term impacts are going to be to residents, folks working in the field during the event, to our economy, to our environment. Census issues will impact federal funding, obviously, and state and federal assistance will be long gone by the time we figure all this out. Gaps in emergency response, because this was so large scale, and this is a lesson for the rest of the state. There are not enough human resources in the state of California through mutual aid to support a disaster of this size and this length. The duration, the mutual aid is awesome. For about a few weeks, you can get so many resources. 4 or 5 months later, there's no resources out there. We, especially medical personnel, animal control, sheltering thousands of animals. there weren't enough people in the state to come up and help support. Human sheltering is not sustainable. We are on 4 months and 5 days, and we are still sheltering people. Red Cross doesn't have enough volunteers across the nation. Supplies were not available. They literally ran out of supplies during this event. We went all over the state, out of the state to get certain supplies. There were not enough. Technology failed us. Cell towers, phone lines, network lines all burned down. And evacuation routes, if you're planning evacuation routes, make sure you know what's at the bottom of the evacuation route, not just in the fire areas. That bottlenecked in Chico and caused 5-hour backup. Donations management is a nightmare when everyone wants to give. There's nowhere to put the stuff. And debris removal, as Mr. Tippin mentioned, in federal law it says may. It should be shall for an event of this size. The hoops we had to jump through to justify debris removal, it was insane. And local emergency management staffing is not sufficient. Butte County has one person, that's our emergency manager. Let's see, disaster recovery challenges, same things Mr. Tippin said. Our resources are stretched thin, we're not doing our day jobs. FEMA's model for interim housing, I don't believe the other, most of the other fires required the interim housing that we're requiring for 1,500, 1,600 households, so 4,000 or 5,000 people. There is not a mobile home on the ground yet, so we're going on, 4.5 months, because FEMA's model is we need a big piece of land with utilities right there, and we'll put 1,000 mobile homes. You don't have that in rural America. And so they keep scratching their heads and looking at us. Well, why can't you give us property with utilities? Because we're rural. There's not big land in our cities. The amount of money they have spent to date to not have a mobile home on the ground probably could have built affordable housing and would have been a reinvestment. So when I retire, my goal is to go fix federal law. Also, at the local level, every resident and jurisdiction in the state, you need to hear this. Be prepared to step up and support interim housing. We have public outcry, political pressure, perceived negative impacts on my property. Don't put those people there. I'm not sure who they think those people are. It's us. But it has been a nightmare. And so I really tell other jurisdictions, be ready, be strong, especially as elected officials. And then infrastructure is critical to recovery. Water systems, septic solutions, and roads, funding is vital. And the model that the state and federal government have is you go fix it, Butte County, and we'll reimburse you later. We don't have $30 million. We don't have $50 million. The utility that does water doesn't have the $100 million. So bless their hearts, our partners are working with us, and we are reinventing things, or we're inventing things that have never been done or allowed in previous events. And finally, manage local expectations surrounding state and federal assistance. Our partners have to listen to local jurisdictions on what our needs are. Task forces in Sacramento should not be making decisions on our behalf without our input. And changes in direction in the middle of a disaster are not helpful. Things we had in writing, yep, do this, go forward, and then do a 180. You can't do that. The public doesn't trust government right now very much because of the 180s we've had to do. And then we're told constantly, don't make the decision based on cost, just do what's right. We have to take cost into consideration. We don't have unlimited resources. So what's next? I'm almost done. We must work together to identify gaps and solutions in the emergency response system. I think we're all ready to step up and do that. We need a new playbook for large-scale disasters. Systems are too complex, information's fragmented, and we can't figure this out in the middle of a disaster, which the state, feds, and us, that's what we've had to do, sit in a room and go, what do you think we should do right now? No one knows in something this big. Legislation with triggers should be in place that is not event-specific, so that new legislation doesn't have to get written every time there's a new disaster. Building standards in the high fire severity areas and wildland-urban interface are needed, and this is important, to protect the structures. The fires start in the trees, they don't start in the homes. And so we need to build homes that can withstand to some point as we manage forests and do fuel reduction in the forests. And we need to ensure local capacity. FEMA and the state cannot do their jobs if there's not local capacity in the local government to work with them. And you have a real discrepancy across the state of California in what you have in emergency management. And then sheltering and interim housing, as I said, a paradigm shift that looks investing the same amount of money in permanent affordable solutions and not spend a bunch of money to put housing in and spend a bunch of money to rip it out. That's kind of useless. And I know insurance is big. Government would rather everyone's insured and then insurance cover it. But in California, there's people who have to choose to have a roof over their head and they can't afford insurance. And on that note, thank you for your patience, for listening to my very long list of observations and impacts, and I wish you luck in carrying out your charge.
Thank you, and no patience required. I was just sitting here thinking, I don't know if our commission will take on all these issues, but we'll definitely refer this video to somebody, the other people in the system who have to. So, yeah, thank you for taking your time. Clearly, you got a lot on your plate and taking your time to speak with us today.
It was good therapy, thank you.
Please.
Good afternoon, Commissioners. Pat Minter, Public Works Director. I wanted to speak briefly about land use and the land use history in the Carr Fire area. You heard from Mr. Tippin about the fire getting in and taking about 200 homes in the city of Reading, but it came out of the unincorporated area. And it's rural residential area, and with 800 homes were lost there. And the center of the unincorporated area in the Carr Fire was the town of Shasta. And there were high fuel loads in that area, a lot of brush. So the history is useful to understand how we got here. How did we wind up with thousands of homes and 10,000 people in this relatively rural area? The history of this area goes back to the gold rush in 1880. Well, gold was found everywhere else in California. Here it was a massive sulfide deposits of copper. And mining took off in a big way in 1850 in this area. The town of Shasta quickly became one of the largest cities north of Sacramento. A population of 3,500 people, and it was the county seat within a couple of years. And that boom went on for about 60 years. And there were patents and grant deeds and town plats that were recorded, creating thousands of parcels. And there were roads that were created, just dirt roads, and mines were created, and thousands of people came to work in those mines. The total population was probably over 10,000 people in the mining area, which was pretty much the Carr Fire footprint. And the mines dug into these sulfide-bearing deposits of sulfur and dug out the ore. That opened up acid mine drainage as water combined with the sulfur and oxygen, dissolved the metals, drained out and killed all the fish. Also, the ores were dug out, millions of tons of ore over the next 60 years, and were roasted in smelters. That created smelter fumes, and the fumes, they're a problem for public health. Huge smokestacks were constructed to try and get that away, but it also killed off all the vegetation in the entire area. For miles around, you wouldn't see any trees or brush or anything. The pictures are really kind of a moonscape. Eventually, in the 1910s, lawsuits were brought by agricultural interests down the valley, claiming that their crops were being damaged. And the courts upheld that, and an injunction was issued, and around the late 1910s, all the smelters were shut down. Well, that created an economic problem for all these folks, but you had all this infrastructure in there. You had these homes, tens of thousands of parcels, whole town sites, and roads and crude water systems, not much in the way of water delivery. There really wasn't much infrastructure to support this. And economic problems. Some people moved away, but there was still a large population there in this existing infrastructure. Around that time, the forerunners of the Subdivision Map Act came along. Local agencies started to have some control over local land uses. In 1929, the counties were able to actually condition development. Gradually, brush started to grow up in the watershed, deep, dense brush, not trees, because the soil still had some residual contaminants, and brush grew up first. So that created a severe fire hazard. Wasn't too bad. For many years it was managed, but gradually the towns, some of them emptied out, others there was consolidation of existing parcels. The town of Corinth completely went away, but the town of Shasta shrunk, but continued on. And in the 60s, public water was brought in. The Trinity project was constructed, and the original plan was just to build a dam in Trinity County and pump that all the way to the Sacramento River. But local input encouraged them to build Whiskeytown Lake along the way. It's a shortcut, less digging, and a local amenity for recreation. The National Recreation Area was created, and 4 water districts were created in the local area: Shasta, Keswick, Clear Creek, and Centerville. And that brought water to a lot of these existing parcels. And there were people living on these parcels. At the time, Keswick, for instance, was created in 1894. It was platted. Dirt roads, no infrastructure. There were 151 homes when the water system went in that were served by that. And there was growth over the next 60 years, about 60 homes were added. So not a lot of growth. And there were 500 parcels. So a lot of these were consolidated for that growth. The county took over the road system. The county built a fire hall in Keswick. The county built a community center. And, but all those were destroyed in the fire. Fire came through and took out all of that because of the dense brush. There had been some efforts to manage the brush over the years, but it hadn't been very successful. Trees had begun to grow up. There were some controlled burns, but it was a massive challenge. The Iron Mountain mine, the mines were all shut down. Gradually, the EPA came in and cleaned up the Iron Mountain mine site, the worst polluter of surface waters in the United States. Now that's been completely captured and treated, and there's no longer any fish kills coming out of that. The area has really recovered well. There's been some large lot development, a few with proper infrastructure, secondary access, water systems. But the total population within the area was probably similar when the fire broke out to what it was 100, 150 years earlier. It had been a churning and variation. The new lots are, it's more of an upscale neighborhood now. The test scores in Grant School District, for instance, are some of the highest in Shasta County and the top 10% statewide. So it's become a very attractive area on the west side. So the county had some difficult cards dealt with this area. The fuel loads were, it was inevitable that eventually that fire was going to happen. But now that fire has gone through and it's taken out that understory. And efforts are being made, grant efforts with cooperation with nonprofits to manage the forestry of what's coming back. And it's kind of an exciting time, I think, also. The debris has all been cleaned up and rebuilding has begun. The lots exist. The lots were created back in the 1800s. Maps were recorded. But it's an exciting time, and I would encourage state and federal agencies to continue to work with counties in furtherance of the rebuild.
Commissioners, questions? Commissioner Khan, thank you.
I don't have any questions. I have some observations. Governor Brown said that the fires are the new normal, and we have to accept them. I have to say, Ms. McCracken, I am incredibly impressed by your bravery. We went through Paradise today and toured it. It's unimaginable. And those of us who are lucky not to live there and see it on television don't have any notion of the scope and devastation. And your description of it, although it resonated, it obviously didn't do the horror of it justice. I do think that we need to do more than just listen. And I would suggest 3 things that the commission should think about doing. First of all, I would say to you, Mr. Tippin, and to you, Ms. McCracken, that there's no way that we can possibly respond to all your needs. It just can't be done. But it's very important, nevertheless, to help us by prioritizing the things that are most important and suggesting to us the things that the legislature and governor can address. I think I'm not speaking out of turn to tell you that they really do want to know what your most important needs. I mean, you can give them a list of 109 things, but the first few are the ones that they're maybe be able to address. So I don't think we should give up hope, but that needs to, and Ms. McCracken, you made that observation, it needs to come from you. So that's the first thing. we could use here in this community and all the other communities, understanding of what your most immediate true needs are, so maybe we can help direct that. The second thing is, because it is the new normal, underscore the word new, I'm sorry to tell you, but you're the first, and therefore you're the people who have to teach us the lessons. And it would be a really terrible thing if from this we didn't learn lessons from these things. You have imparted a lot of wisdom to us, much more than we could possibly absorb in a short period of time. But, and I know you're not, right now you're looking at $1.8 billion worth of debris, and you're looking at a $6.5 million unpaid bill that you hope you don't have to pay. And you're probably not thinking, well, helping somebody else, making a list of lessons learned is not really high on my list. But that's really important for you to do. Nobody can imagine what you've been through. But what they can do in later years and figuring out what to do over time is work on the lessons learned. So I just think for us, we can't do this for you. We can't even figure out the lessons learned. But we need, I think the commission needs to start moving the state in the direction of figuring out lessons learned, because it's the new normal. The third observation I'll make about this, and I was benefited today by being taken around by somebody from CAL FIRE who showed me the terrain, who showed me the origins of the fires. And we had a very robust conversation which mirrored the conversation we had at our last hearing. And that is that you may have had, pardon the pun, the lightning strike you, but it could happen anywhere in the state. And I actually don't think that the state has absorbed that information. I don't think the communities that the report that the governor has commissioned and CAL FIRE has identified, it's just not real to them. And I think to the extent CAL FIRE and the people who understand the combination of wind and climate and the like understand these things, my hypothesis is that there is a real threat to a lot of communities. And I think that in order for them to really, for us to really step up to the lessons learned, we have to understand more about what happened and how it can apply. That's my hypothesis. And if I'm right, I think that that's an obligation of the commission to let the legislature and the governor understand that Governor Brown was right. It's the new normal. But, and here's the important point, it's the new normal isn't just a fire that randomly hits a few homes. The new normal might be other communities that are devastated, other Shastas, other Paradises. And I think that the efforts of the state to respond, if the people of various communities could visit Paradise and actually think this could happen to them, the reaction would be very different. And if that's true, as explained to me by the fire people today, that you had an ignition site 7.5 miles away that went through a forest, that jumped a river, that hit a city that never had been ignited before. If that's true, that can happen to other places. That's very sobering news. And we need to, at the commission, we need to think about if that's true. And if it is true, we need to identify that as something that we need to address, because this academic and financial exercise that we're going to becomes way different. And Mr. Tippin, thank you for reminding us of it. It's way different. It's a much more human, horrible thing when you say to yourself, our city could turn out and have that terrible thing that happened to Paradise. So thank you for sharing your stories. Thank you for welcoming us to be here. It's very sobering. Although the financial issues are huge and the legal issues are immense, I think and I'm sure Pedro will tell me I'm right about this, the human issues are way, way, way more grave.
Thank you, Commissioner Khan. Commissioner Nava.
Thank you, Commissioner Khan. Mr. Tippin, you wisely made reference to the other kinds of costs that aren't connected to infrastructure and about the human costs. And I met a fat little dog today in the morning when I went out to go see your sundial bridge. What a gorgeous, beautiful piece of architecture in a community where you wouldn't necessarily think you would find that kind of construction. But the fat dog story is I was talking to a woman on the bridge, and I like dogs. We have 2 little ones at home, and this was a Chihuahua, and she apologized because the dog was fat. And she explained it by saying that because of the fires and because she has respiratory problems, she couldn't take the dog out for its regular exercise. That is an example of the kinds of impacts that occur in communities when you're overwhelmed by the sorts of disasters that you've confronted. And Commissioner Khan is right about the lessons to be learned. We're all Californians, whether you live up next to the Oregon border or you're down in El Centro and Calexico. We're all Californians. And think about the cost of your community in mental health services. People who are suffering from post-traumatic stress disorder. And it's a California problem that we have to address because the number of people that you have that don't have places to live are going to move someplace else. And you have to think of the impacts in those other communities where people are moving to. And they don't have the infrastructure to deal with the additional population. And that's besides the fact that people love the places where they live. They love Paradise, they love Redding, they love Whiskey. All of these communities up here have a particular culture and a strength and a beauty and a resilience because they've confronted difficulties and challenges and they've survived them. And they are the very fiber of what makes this state so incredibly diverse and rich. So this isn't a problem for rural areas. This is an issue that has to be addressed for all of us here in California. So when I was talking earlier about how do we structure this catastrophe fund and who gets to pay into it, I think the people of the state of California ought to pay into it because we're all residents and citizens of this state. And we all have this same humanity, or we should, that connects us in such a way so that your burden is my burden. I live in Santa Barbara. We had a fire in Santa Barbara. We had the slides. People lost their lives. Homes disappeared. Others were buried in the mud. And you're absolutely right. The response by the emergencies folks in this state is exemplary. I was the chair of the Joint Committee on Emergency Services for a while when I was in the legislature. And the model that we have here is emulated by other places all across the country. And that's because of the vision that we share about, and that when my neighbor has a problem, I have a problem. And I've got an obligation and a duty to help that person along. And what Commissioner Khan is saying is absolutely right. Because other cities are going to be confronted with how do we navigate these permits? Where do we get money up front to wait to be reimbursed when you don't have the money? When in a community like this, you have I think it's Mercy Hospital, and then the city and the county are the largest employers, and one of the next biggest job places is Walmart. That's a reality that Sacramento and legislators in Sacramento have to understand. And part of what you're confronted with is you probably have, you have one assembly representative and one senator. You go to LA, there's about 79 of those people. So that all the attention is focused in San Francisco and Los Angeles. But the fact of the matter is that everybody who lives in places like this are just as important and deserve the same resources and the same attention and the same dedication to maintaining those things that make your places special that anywhere else in the state does. And I want to thank all of you, heroic measures and efforts that you've taken. Dedication to the people in your communities. I mean, 3 sterling examples of public service that I suspect are being repeated over and over and over again in the cities and the counties where you live. Thank you for taking the time to share this with us. And you're right. We all need to understand and identify and get our arms around what it is that what you went through and what you're going through. And thank you.
Thank you, Commissioner Nava. I also wanted to thank you again for your coming and your comments, and I think we will all reflect on what you have to say, as well as when we hear from representatives in our other cities we visit. I had one specific question for you around insurance. That's what we were talking about a lot today, and really where some of the gaps are, and we'll talk next in a few weeks about the availability of residential insurance. But could you just speak to, in terms of the facilities that you operate, what do you have insurance in them? What does that market look like? Because I think we're trying to think about what does a big pool look like, and does that need to include some of the costs that you might be facing? They are both pointing to you if you cannot see them.
So we, for most of our infrastructure, we are self-insured. We do carry excess liability insurance. And so that has a deductible up to $500,000 and it goes up to $40 million beyond that. And we do have extra coverage for our power plant, about $100 million on our power plant in case of catastrophic loss at that location. And we have vehicle insurance and some other property insurance of lesser value, but most of the catastrophic stuff is self-insured. Interestingly, we are now receiving claims as well. Claiming the city is responsible for the damage done within the city boundaries because of car fire. And so that would have to go against our excess liability insurance. And presumably that we have adequate immunities in statute, but that would hit that, and hopefully our overall obligation would be $500,000 in that regard.
And as you noted, please, Mr. McCracken. Well, I just wanted to finish up with you, Sarah, regarding the fact that you do have a publicly owned utility in your city, Reading, and did you have any other considerations you'd like us to be thinking about as we're thinking about the liability standard around utilities? I think you were here probably for the earlier conversation.
Yes, and I for complete transparency, amongst my many duties at the city over the last 15 years, I spent 6 years as the director of the electric utility as well. And I think that the points made in terms of strict liability are an important one. I would also state that, we as a publicly owned utility are very diligent in the expenditure of our resources for items such as, improvements. For instance, we don't have smart meters. We have great reliability. We have redundancy. We have a 115 kV loop that goes around the entire city. And so the idea that we have to pinpoint better in terms of where our outages are just isn't real for us. We're also a flat rate base. We pay 15.2 cents per kilowatt hour for residential households, so we don't have a time of use. And so, investments of $40 million at the expense of a ratepayer doesn't make a lot of sense. On the contrary, we spend significant money on tree trimming in and around our lines, and to make sure that we have the ability to identify where we have hot spots. We do annual inspections, both infrared as well as on foot and by helicopter. And so we do spend a fair amount of money on that element to make sure that we don't have those issues where negligence could become an issue. And so the idea of strict liability for an electric utility is very concerning to us as well, because we spend a lot of time and effort and energy, no pun intended, in making sure we don't have those instances.
Would you say, this is getting a little in the weeds, it's not in your space, but given your previous role, would you say that you have a prudent manager standard? I mean, you've done your best you can, but do you have a sense of what is prudent?
Yeah, so what we do, we work very well with the California Municipal Utilities Association, and we follow much of what is out there from CPUC guidelines. Okay. So we don't consider CPUC to have regulatory oversight of us. We have our city councils and the legislative oversight, but we follow much of the same standards. And in fact, I would say that most public utilities either meet or exceed any of the standards of our IOU brethren.
Thank you. And Ms. McCracken, the last word, please.
So we are the same as Reading. We're self-insured with excess coverage. I will speak to the fact that our roads are not insured and our roads are heavily damaged. And then even though our facilities are insured, it doesn't pay to cut trees down. And we find a lot of residential insured have the same issue. There is not money in there for all these burnt trees that are standing.
Thank you.
And I would reiterate also, we were insured for the fire hall, we were insured for the community center, but our roads are not insured, and there's some issues with damaged road facilities, which they're not insured, and also upgrades to meet modern environmental standards, hydraulic standards. There always seems to be more bill than there is reimbursement.
Thank you very much. I know there was a request from some commissioners for information. Our executive officer will follow up with you on the nature of that, so that we make sure we give you, I know you have a lot on your plate, so we don't want you to do extra things unnecessarily. So we will organize it to be complementary to what you've already, clearly, the feedback you've been giving the city. So thank you very much.
All right, thank you.
Thank you. And next, we're gonna wrap up now with public comment. We have about 5 or so speakers, and so I'll just call you one at a time. Cedric White. And I say some of you write like doctor, so I'm gonna ask you to say your name again.
You said my name correctly, Cedric Dwight, and I'm speaking to you now as a Shasta County WUI resident, so I'm in the very high fire severity zone, and I know you're gonna go into residential insurance next
Yeah, but you
meeting.
can speak to whatever you want.
That's what I want to touch on, with the chance to share an idea that could possibly provide equity or an equitable solution for folks that take personal responsibility about their own place of living in the very high fire severity area. I'm faced with a doubling of my cost of insurance. I got dropped. My insurance is doubling because I'm in the box. I'm in the very high fire severity box. But my house, I know fire, and I've had other fire professionals over. My house is not it's not threatened by either the vegetation. It's built with the resistant construction techniques and that sort of thing. I have a 2-inch ag line to my house. I could literally fit the water line with, a connection for fire personnel, driveways all up to snuff. Great. But what I'd like to be able to see done and make this provision and make it mandatory would be for when you get your 4290 inspection and you have the fire professional out there, give them the authority to move that individual residence from a very high fire severity hazard rating to something that's high or even moderate, because I don't believe my particular residence is even anything more than moderate. Now, granted, this won't apply to everyone, but if you're going to do your due diligence and put the effort into it, it'd be nice not to have to, incur those expenses. So that's my idea. Great if you guys could facilitate that. That's all I have. Thanks for your hard work.
Thank you. Thank you very much. Next, Joshua Schaefer, and then followed by Cedric White. Was that?
That was me.
That was you again? Okay.
Mr. Schaefer.
Okay. Dan Greeny, followed by Dylan Gibbons.
Mr. Greeny also left. He wrote some comments that I've given to Evan.
Okay. And then finally again, Julia Donato, you wanted to make some final comments? Oh, sorry. Yes, Dylan, please. Go ahead, sorry. It seemed like no one was left.
Yeah,
so please, welcome.
I didn't want to miss the end. Commissioners, Dylan Gibbons with the California Special Districts Association. I just wanted to let you know that we're here. We are the folks who are representing utility districts, water districts, fire districts, healthcare districts, resource conservation districts, pretty much anything that ends in the word district other than a school district. So a lot of the communities that have been impacted, it's our members, our utilities, our service providers are the ones that are helping to rebuild those communities, and they've also been impacted. It was mentioned about the Paradise Irrigation District. When you have an irrigation district, it's not going to be reimbursed when the state does their property tax backfill because they're an enterprise district. They receive rates, and when all of a sudden you lose all of your ratepayers in a day, it has a significant impact. Yet that water district is still going to be there and need to be there in order to rebuild those communities. So we look forward to working with this commission and just serving as a resource. If we can help bring our members together to provide you with information or any data that you're looking for, happy to do so.
Thank you.
Thank you.
Oh, yes, it is.
This is a comment that came in, Dan Greeny, who I believe, and I wanted to read this in the public record. He had a recommendation, looks to be a recommendation on for fee on carbon emissions that could socialize at least the climate change piece of the fire costs and could subsidize or fund or reduce the insurance risk.
Is he with our grandfather's children? Is that the same gentleman?
It's the climate,
Oh.
yeah.
Yes.
I have a list.
Okay, we had just don't know, we have public comments that are written, that are posted on the website for the commission, and we did have a set of comments from our grandchildren's future, which touched upon that idea as well. Julia Dunn.
Thank you again. I come here today with a variety of hats. My name is Julia Donahoe. I'm an architect, I'm an attorney, and I'm a general contractor. There are about 100 of us who are architects and attorneys in the country, so they're few and far between, and I have a partner who's also an architect attorney. And during the fire in Santa Rosa, I acted as the chair for the Firestorm Recovery Committee. So I wanted to come today and just say a little bit about the American Institute of Architects. We have chapters in, I think, 22 different regions of California, and we have a state chapter in Sacramento. We've created a disaster toolkit for unrolling in disaster, and I think we were quite effective in Santa Rosa with permit streamlining, talking to officials about the rebuilding process, talking with homeowners about the rebuilding process. They let us into the LAC. We had a table with the North Coast Builders Exchange, so the homeowners' first experience wasn't just government people, but they got to talk to how am I going to get back, to give them hope from the beginning. I thought that was very important, and I'd like to see that continue in statewide and other disasters. I think it was very helpful for people. We also focused on housing, temporary housing, infill housing, worker housing, ADUs. We've got ADUs moving in our community that were never happening before because we really worked through the issues that were blocking them. Through this disaster, we talked about materials. We brought lots of different suppliers of different kinds of materials to town, and it was a very useful resource. Creating resilient communities is really an important issue for the American Institute of Architects, nationwide and globally. This problem is not just happening in California, it is happening everywhere. I served on the national board of the AIA, and my own classmate on the board was in Puerto Rico, and I was like, well, come here for a visit and get out of that mess. Get out of it, and then you can go back and think straight. And a week later, I was like, oh, don't come here. And then our other classmate was in the Carolinas, and she's going to be president of the AIA next year. So the AIA takes it really seriously, and I hope that we can help in any way. We have a lot of people who are interested in helping. The second thing I'd like to, my pet love on my committee was we did energy, we did sustainability, all that stuff. My pet love was whole neighborhood rebuilding. How do we increase the statistics on rebuilding whole neighborhoods? Because when I went up to Lake County, we had 20%, and I was like, we have got to do better in Santa Rosa. And we found that because of the insurance and the obstacles of rebuilding, it was really easier to do it in the master plan communities. But now we've motivated people to do that. So we brought people up from San Diego. We started to use those resources. Even though we brought a contractor from way far away into our town, he was welcomed, and he drove a competitive advantage. He drove a competitive interest. Once he put signs up in the neighborhood, got 80 people to sign up in 185 homes lost neighborhood, then everybody wanted to sign on their lot. That neighborhood is already looking like 60, 70%. It will be, by the end of the year, it's gonna have phenomenal statistics, Mark West Estates. Then we met with like 10 major contractors and talked about Coffee Park. How do we get 1,300 homes back in Coffee Park? We drove that train. The AIA helped drive that train to get more people building. We're still working on the larger community where everything was unique, master plan. The insurance is the huge obstacle. So I do want to talk to you about insurance.
Yeah.
And I gotta wrap this up.
Yeah.
So I two things. One, as a contractor and an attorney working in this fire, we have consumer protection laws. BPC 7159 is put in place to protect consumers from contractor fraud. The CSLB tries to enforce it as best they can, but it doesn't have a lot of teeth in keeping fraudulent contractors from coming back into multiple communities, taking a huge amount of money and leaving. The contracts, the ones that try to meet the spirit of these contracts, they're not working. And I would love to talk to you further. It doesn't have to be a long conversation today, but we really need to look at how these contracts are protecting consumers or not. And we need something in place that really does protect consumers and provide a good construction contract. Because this is meant for pool repairmen and stuff like that, and it kind of got applied in disaster for a vulnerable population. We really need to revisit BPC 7159. And that's a contractor issue and a homeowner issue. And then the last thing was the truth in insurance. So I've dealt with a lot of homeowners and their insurance, and I gotta tell you, nobody knows what they're buying. Not a single person that I've talked to knew what they were buying. None of their agents knew what they were selling. I can show you 3 different insurance companies that gave people a $300,000 coverage A. One pays out at about 600, one pays at 800, another pays at 1.2 million. And the agents and the homeowners had no idea what they were buying. And we need truth in insurance. Like we have truth in lending. When you buy your insurance, you need to know what it's paying for. Is it gonna cover your equity? Is it gonna cover your mortgage? Is it gonna cover mortgage and equity? Is it gonna cover rebuilding? When, after the Oakland fire in 91, in 97, we took away guaranteed replacement cost value. In California, you cannot buy a guaranteed replacement cost value, but there's many other schemes of insurance, many other plans. People don't understand the differences. But what we do have is a system in place that is creating confusion, and people don't intentionally underinsure. They're like, insure my house, and they pay their premium. And we have no way in telling them when they're purchasing what they're actually getting. We need to do that. So thank you.
Thank you, and we look forward to continuing to have your comments. You've already provided a lot of information for us today. Is there anyone else who would like to speak to the commission? Please, sir, welcome.
My name is Roger Yeagle, and I'm a resident of Reading. Was evacuated twice during the car fire, and was one of the lucky ones that came back to a home that was unaffected by the fire. I also, in the past, was a Trinity County supervisor, and I have followed this issue for about 20 years or so. I have an op-ed that I submitted to the Record Searchlight about 11 years ago. I'd like to leave that with the commission. It is still very pertinent to what you're trying to do, and you're doing extremely important work, believe me.
Thank you, sir. You can provide to our executive officer.
Okay.
Thank you for your service.
Thank you very much.
Is there anyone else who would like to address the commission? Commissioners, any final comments?
Yeah, briefly, I want to once again thank Chairwoman for the way you conducted the meeting and express gratitude to the supervisors of the county for providing us with their hospitality and a place to meet.
Well said, and thank you all of you for spending your time today for this important issue. With that, we are adjourned. We'll be announcing on the website soon location and date of the next meeting, but it will be in early April. And in somewhere in the state.
I can say we'll be early in April in Santa Rosa. We're still working on lining up the date.
Breaking news, it'll be in Santa Rosa. See you there. Thank you very much.